appellate side means नहीं?
नहीं.
What's your division? The application item number one.
My lord, I appear for the appellant. My lord, I'm praying for a short passover. I'm being led by Mr. Dutt. He's on his way. Kindly gives me a short passover, man.
Executive assigned matter. Item number two.
Starting in turn.
My lord, I appear for the respondent.
Wait, please, your lordship. Wait. Just hold on.
Robert here. Mr. Diary,
Yes.
we'll take it up in the second call because
Yes.
you are likely to take a little time. So run through the list once.
Item number three.
I am for the respondent, my lord.
But I'm for the appellant division. I'm led by
Contempt.
Passover.
Appeal from degree. Item number four.
No, Lordship, item number 4, I appear for the appellant. Mr. Pranit Bagh is leading me. I think he's stuck somewhere in the traffic, Lordship. So if the matter can be taken up sometime next week, if I may prefer or not today.
Not today.
Grateful.
On the prayer made on behalf of the appellant. On the prayer made on behalf of the appellant, let the matter stand adjourned for the day.
Appeal from order. Item number five.
My lord, I appear for the appellant. So the respondent isn't here. My lord, only one thing may I pray for, my lord. My lord had granted me leave to file a supplementary notes. There's already notes on argument file. Lord, I prepare that. If my lord will kindly keep it on record, my lord, I've already served upon my learned friends for the respondents.
Supplementary notes of argument filed on behalf of the appellant be kept with the records. You're for the appellant.
Appellant, my lord.
Be kept with the records. The paragraph. The respondent is not represented. Paragraph. Let the matter stand adjourned for the day.
Item number 6 and 7.
Blood 6 and 7, I am for the respondent, Miller. We are ready to respond, provided the appellant is there. Blood, we will be waiting for the second call, Miller.
Passover,
You're
Passover, Passover.
Item number 8 and 9.
My lord, I am opposing these appeals.
Passover.
Your Lordship, I'm for the appellant in.
Your Lordship, on item number 10, Your Lordship, I am appearing for the appellant, Your Lordship. Your Lordship, I am seeking 3 weeks extension to file my supplementary
No, my
paper.
lord.
Supplementary? Supplementary what?
Supplementary paper book, Your Lordship.
My lord, in this matter, whatever documents, my lord, used before the learned single bench, they are, my lord, not filing before your lordship. Every time we are giving
Your
them a
Lordship,
notice,
we are.
and they are now saying, okay, we are doing. My lord, in that way, my lord, we are very much suffering, lordship. Because I cannot wait.
Why you're suffering an interim order?
No, interim order, it is an appeal from arbitration order, my lord, and they have secured the amount. But my lord, I am in a totally debt trap due to the action of the railway authority.
Why do you need to file supplementary paper book?
Your Lordship,
whatever documents we can place before your lordship.
Your
during
Lordship,
the
counter
hearing.
statements of facts of before the arbitral tribunal was not in the Your Lordship previous paper
Why?
book.
Then pay cost for it.
Your Lordship,
Every time we are giving one after another.
1 week. Do it, or without it, we'll hear it. Do it. Just because it's Union of India doesn't mean that you can claim all sorts of indulgence.
Otherwise, we will show the documents before your lordship during the hearing, my lord.
देखिए आगे कोई order আছে কিনা দেখি তো। On June 30, 2025, on the prayer made on behalf of the appellant, 3 weeks' time was granted to the appellant to file supplementary paper book. Stop. paragraph. Today, comma, again, adjournment is sought for. No, today again, further 3 weeks' time is sought for. Stop. We are not inclined to grant so much time. Stop. The concerned officers of the Union of India should pull up their socks and file the supplementary paper book within a week from date. Stop. This extension is peremptory. Paragraph lists the matter as শুক্রবার তো Monday week করে দাও Monday week এর তারিখটা বলে দাও
Grateful.
Obliged, your lordship, much obliged, your lordship.
Hero.
Item number 12.
My lord, item 12, I beg to appear for the award debtor, the appellant, my lord, before your lordships. My lord, I am led by Mr. Jointham with
You
you.
know, remember Passover? It's
Yes.
unlikely to be taken up.
My lord, also, my lord, the matter was heard on one occasion when your lordships were sitting in a different bench. So, my lord, I am not sure if your lordships would be
No, we will hear it afresh. This
very
bench.
well, very well, grateful.
Item number 13. Item number 14 and 15.
Cross 34th, my lord. 14 and 15. I think Mr. Jishnu Shah is on the other side.
Very well.
Item number 16.
This is the matter Lordship has heard substantially.
Yes.
Lordship, can I request for a similar time
Yes.
on Monday or Tuesday if it's
দেখো
possible?
তো Mr. Singh is opposing you, no, Mr. Mitra?
Anuj Singh. I will tell him. He's
সকালে 12:30 গতকাল তো 12:30 ছিল এটা তাহলে মানডে 12:30
12:30. I will tell Mr. Singh.
Number 17. For hearing, item number 18.
18 is my appeal. The paper books are ready. We have also served. It's a trademark appeal. Can be heard.
চলো সেকেন্ড কল করো
But may I file the paper books before your lordship or at the second call?
ডিপার্টমেন্ট I think you should
The
file.
department is not accepting. That's
Why?
why I mentioned. But firstly, the department is indicating there is no direction for filing the paper book. It's only for preparation of the
কি
paper book.
কৌশিক
And that's also another. The time had expired, but thereafter we had prayed for extension and it was granted. But it's a technical.
So in spite of extension they are not accepting
They are not extended. That's what I'm told. That
because there's no direction for filing.
filing, it's only preparing.
Concerned officer should report to us. হ্যাঁ এখনই দেখো
Grateful.
হ্যাঁ
Grateful.
Second call, de-application, item number 1.
My client's conduct was so deplorable that even this learned judge was very upset. And he's closed my right to lead evidence or cross-examine. Yes, I know there is a question of maintenance, a commercial suit.
commercial
That this problem is there. But all I can be, since Mr. Bose is there, I have advised my clients, to apply before the court and persuade the court to
yes
put my client on some costs, and if my right to cross-examine can be reviewed, because It takes a lot, my lord, to upset this court.
We'll reserve that liberty to you to approach the learned single judge.
Only thing is one indulgence. I'm told, my lord, the suit is fixed today for further. If my lord, I can take Mr. Bose's consent.
That Mr. Bose is there.
Because I need that time.
Issue. Issue.
Can't give my consent, but I will not be vociferous. in my opposition.
Correct. This appeal is directed against an order dated June 16, 2025, passed in CS Com 589 of 2024, whereby, the learned judge closed the cross-examination of the plaintiff's witness by the defendant. Stop. We find from the order impugned that the learned judge was prompted to do so in view of the conduct of the defendant who, according to the learned judge, was dragging the matter unnecessarily, causing inordinate delay in progress of the suit. Paragraph. Firstly, the order impugned does not appear to be an appealable order under Section 13 of the Commercial Courts Act, 2015, read with Order 43, Rule 1 of the Code of Civil Procedure. Stop. Firstly, the order does not. Stop. Hence, we do not entertain this appeal, which accordingly stands dismissed along with the connected application. Paragraph. This order will, however, not prevent the appellant from approaching the learned single judge with an appropriate application in accordance with law.
Great. But now that it is over, only 2 instances are referred to here in writing. There were 2 instances before that also where they prayed
I
for.
told you, Lord, it takes a lot to upset that learned
Yes,
judge.
yes.
Then-
Yes, correct.
Very great.
But I understood that Mr. Bose will not object to today's adjournment. This would be the 5th.
That is
instance.
between the two of you. We say nothing.
Second call, item number 2. Special assignment.
Wait, please, Your Lordship.
We have heard you at great length.
Well, wait.
So now please wind up.
Well, I'll wind up. I'll do. But
Mr. Mukherjee is appearing.
do I need to? Do I need to refresh the memory of this honorable court, my lord? Need to refresh the memory of this honorable court with 5 minutes, my lord. But this is an appeal under Section 37 of the Arbitration and Conciliation Act, wherein the Section 34 filed by the Union of India Railways was dismissed. The award is of a 3-member panel and an unanimous award.
Mr. Bikash Bhattacharjee was one of them.
Yes.
Yes.
Justice Torun Chatterjee, Justice Bikash Bhattacharjee, and another honorable judge of this honorable court. And my lord, the award was unanimous. This
Yes.
this relates to wagon investment scheme that was floated by the Union of India Ministry of Railways. Now, what the investors were to do is invest in rakes. Invest in rakes, which would go into the general pool of the railways. And what they will get out of it is they will get a supply, a guaranteed supply of rakes, and they will get a freight rebate. In this case, there was a guaranteed supply of 6 rakes per month.
After 10 years or 12 years.
10 years. For 10, I'll come to that. And the 10% freight rebate that they are entitled to in addition to the guaranteed rakes. But the agreement had a few features, which was basically that it would carry on from point A to point B, which is a station at Orissa, at Jharkhand, to the private siding of the claimant. First at Titagore and then at Holdia, that was added. Supplementary agreements were entered into, and this was mainly primarily for the goods for carrying the goods of the claimant or the investor. The agreement said that this agreement will carry on for 10 years, and on the 10th year, after the 10th year, the rakes would go to the railways, and it will have a zero value in the hands of the claimant, respondent here, the investor. Now, in the conspectus of this, my lord, the agreement was entered into, and my lord, it is an admitted fact that they used the rakes for 9 months. They used the rakes for 9 months. Now, 9 months, why they used the rakes, my lord? And that too, my lord, these rakes were used for 9 months because they could not complete their private siding. They could not complete their private siding. Initially, they asked for 2 railway stations to be used for loading. Well, one is at Orissa and one is at Jharkhand. The Jharkhand railway was the main railway. The railways allowed them for first initial period of 3 months, and then, my lord, 6 months. At the end of the 6 months, they started writing that allow me to continue with the 2 segments to the 2 railways. And my lord, by March of an year, by February of an year, we said that sorry, we cannot allow you to use the public sidings of 2 railway stations because there are other transporters or other investors who are using it. In the meantime, my lord, what happened? Inter-state transfer of iron ores were banned from Odisha to Jharkhand. This happened in April. And when it happened in April, thereafter the investor or the respondent did not load any goods under this scheme. Under this scheme from the railway station, which was designated under the agreement. My lord, this continued for 2 years, and my lord, in 2012, they had completed their private siding. Even after 2012 completing the private siding, they did not use or utilize the scheme by loading a single scrap of iron ore from the private siding. Now, this would be evident from their letters of 2013, which we have placed, and I will not repeat that. That they say that due to this change of event of no transfer of iron ores from Orissa to Jharkhand, and their captive mines at Jharkhand not functioning fully, we could not, use the agreement. We cannot utilize the agreement. We cannot load the goods. They had also applied for a transfer of the loading station. A transfer of the loading station, my lord, the government came up with a circular that you can transfer, but you will not be given the guaranteed number of rakes. You will be given the rebate, maybe they will not be given the guaranteed number of rakes because that will add up to the traffic of that station. So they did not agree to that. But this all happened in 2012. And they terminated the agreement in 2016.
16.
Yes. Now, 2016 terminated. But the first point what I urged is limitation. First point I urged is limitation, which was taken care of by the arbitral tribunal. The arbitral tribunal relied upon Article 55, saying about successive breach. But limitation act, we relied upon Article 113, stating that it is three years from the right to sue, when the right to sue accrues. Now, why we said right to sue accrues? In the termination letter, they had challenged, saying that those circulars.
2016, they terminated. And Section 21 notice was in 2016 itself. So where's the question of limitation?
No, why I'm saying limitation, my lord, is they have the clause of termination says that it can be terminated if there is a change. if there's a change, the agreement type copy of the agreement. But I had submitted the typed copy of the agreement. It says that in the event of termination of the agreement by the investor on account of liquidation or merger with other company or due to any alteration, deletion in the scheme. So they are claiming termination on the alteration or deletion of the scheme. So alteration and deletion of the scheme happened in 2008, 9, 10, and 11. So we say that when the alteration happened, you ought to challenge it within the period of limitation because your right to sue accrued when the alteration happened. Here is the volume 1. Volume 6, 7 है ऐसे वो judgment. Airport judgment. Small 8 to 9. Small
Yes.
they had in the issues framed by the tribunal, my lord, 2 circulars were the focal point of the termination clause, which says alterations of the agreement, of the scheme. Scheme and agreement are, my lord, in parameter. So alternately we can use scheme and agreement. Now, 2 circulars which was taken care in the award or by the tribunal were circulars dated 26/9/2008 and 3/2/2011. 26/9/2008.
Which is at page?
Which is at page 29 of the compilation.
And
my lord, 3rd February 2011, which is at page 30 to 31 of the compilation.
Yes. Key?
Now, my lord, even if we take 3/2/2011 as the last circular which altered the agreement, they ought to have challenged it within the period of 3 years because right to sue accrued.
The arbitrator said it's a continuing breach. Arbitrator said it's a
tribunal said that is their argument. It's a continuous breach. But my lord, here it cannot be a continuous breach because of the simple fact that they have tried to terminate.
This is a post-amendment award.
Yes.
Post-2015. So even more difficult.
No, my lord, we are on perversity. We are on perversity and we are mainly on, my lord.
No reappreciation of evidence cannot. Statutory bar.
But if evidence which were before the tribunal not looked into, then it becomes perverse under Associated Builders versus DDA.
Erroneous application of law again.
No.
Not available to you.
No, but if my lord, evidence which was before the tribunal not looked into, Associated Builders give me that leverage that then the award should be set aside.
Show us, then you have a limited point. Show us that. This was the evidence which was not considered. Show us that.
So basically, my lord, on limitation, my lord, these two circulars, if they've asked for termination, because I've read the termination clause, it is on due to alteration or deletion of the scheme. So if the alteration happened on 3/2/2011, then they ought to have terminated the agreement within 3 years from 3 to 11 at least. So they have not done that. They've done it in 2016. But there's a reason behind 2016, my lord. The reason being, my lord, there are other agreements between other parties, where in Delhi High Court, these two schemes were held to be altering the agreement. So they waited for those judgments.
You said so. Once that judgment came, this party woke up.
So, my lord, this is on limit. This is basically on limitation. But I'm running down, my lord. All have been argued.
Yes.
Now, my lord, the award is on 3 heads. The award is on 3 heads, my lord. The first head of the award is on, my lord, value of the wagons. Now, in the value of the wagons, I had argued, my lord, at length that something beyond the agreement was taken into consideration. And a formula was taken into consideration, which is not a part of the agreement, which is not even a part of the contract or the intention of the parties. And it is inter-railway transfer of assets which was taken, and it is a transfer between one railway to another. It is not a transfer. The calculation is taken. It's a notional transfer between one railway to another, and the formula was completely, my lord, mistaken. And though this agreement does not say what will be the value of the wagons on termination, it says mutually agreed price. But a pointer has been given in this agreement, in this contract, saying that in case of condemnation of the wagons, income tax rules will apply. So, well, if an agreement is silent on one part, that it is mutually agreed price. But if it's not mutually agreed, then what would be the price which is to be taken by the tribunal? The pointer is given in the agreement that in case of condemnation, if income tax rules apply, then here also the depreciation will be according to income tax rules. Because normally all depreciations are according to income tax rules. So the formula has been placed by the claimant before the tribunal is a complete misnomer, my lord. It's beyond the agreement, and the tribunal could not have taken an alternative interpretation of the contract by taking aid of a different calculation which is beyond the contract. And my lord, that tribunal is not a court. My lord, the latest judgment is OPG in that, and tribunal is bound by the agreement. OPG power, which I have also relied upon. And tribunal, not being a court, cannot import, my lord, my humble submission, the value of the wagon, the depreciation, to be from a inter-railway transfer, which is a transfer by books, and it's not a real transfer, and it is between 2 railways. So that formula and that consideration could not have been accepted by the tribunal, and the tribunal should have gone on, my lord, depreciation by under the income tax rules. So, my lord, on that score, the tribunal has miserably failed, my lord, by passing the impugned award on, my lord, the value of the wagons. The next point, the next award is on loss of freight rebate. Now, if there was no freight that is loaded under the scheme, I have argued, my lord, there would be no occasion for any rebate. On the contrary, my lord, if a claim of freight rebate is granted to the claimant, then, my lord, our counter claim of freight should have also been allowed. Because they are entitled to rebate. So I am entitled to the freight. So there has to be a freight to have a freight rebate. I earn freight, they get the rebate. So my counter claim was brushed aside by the tribunal by saying that there was no evidence. In the case of the claimant also, it is only a chart which was placed before the tribunal
Yes.
the chart which was placed before the tribunal calculating according to the entitlement. 6 rex, this should have been the freight rebate. So if that freight rebate would have been given to them, corresponding freight should have been given to us. So if there is no freight, how freight rebate would be granted, my lord? In this case, my lord,
Yes.
so, my lord, on this we had said that the tribunal had completely overlooked the evidence before the tribunal. I had placed all the letters, my lord. On the last occasion, I have placed all the letters saying that when they started asking for, my lord, different station, when they asked for, my lord, while we are given 6 months, and thereafter from, my lord, 2010 onwards, 2010 onwards, there were no 11 onwards, there were no goods because of the, my lord, policy of the government. And 2013, their letters are categorical that we do not have goods.
Have you filed any written note, Mr.
Yes,
Iyer?
yes.
You have.
Yes.
Wind up now. Wind up.
Right.
You've argued
But
all these
I'm just wrapping up, my lord, because
Yes.
now, my lord, the next point was around loss of profit, which is the maximum portion of the award. But in loss of profit, what they did was,
Sesagua. We remember. We've all noted
and on the
that.
last occasion, my lord, I had argued that the said bills, which was annexed to the, did not have the component of service tax. Well, I had prepared a small, but that was not in my notes. এটা একটু দিয়ে দেবেন। আপনি কপি পেয়েছেন? কপি দেয় না? ঠিক আছে। দেয়নি? লাগায়নি এটা? আরে কি রে ভাই?
কোথায়?
এটা দিয়ে দাও। সার্ভিস ট্যাক্স।
আগে নিয়েছিল
এটা আগে নেওয়া হয়। বলেছি আগের দিন তো বললাম। কয়েকটা পরে জাজমেন্ট গুলো দিন। বসো বসো বসো। উঠতে বল। মামলা করছিস তো বলবি না। But I'm relying on section 65 ZZP. ZZP says that a taxable service to any person by any other person in relation to transport of good by railways in any manner. This is the second page after explanation 2. Service tax.
সেটা কোথায় দিয়েছে এক্সপ্লেনেশনে চলে আসছে সার্ভিস
Explanation column 65.
মেন পোর্শনটাই দাও
65.
65 পড়ো
ZZP.
Good.
ZZP, my lord. ZZZP.
That's right. Why
Triple
are we
Z.
dropping one Z?
Triple ZP. To any person by any other person in relation to transport of good by railways in any manner.
But the main definition clause has been missed out.
Yes.
That's what I'm saying.
পুরোটা প্রিন্ট করে দিয়ে দিস না।
Take away this. What is
I'll
this?
give. Well, this is the well, কোনটা? ওইটা। ঠিক আছে, পুরোটা প্রিন্ট করিস নি কেন? Well, I'll give the entire printout. But this ZZP says that, and the taxable melody is 10%. Charge of tax 60 under 66, it is 12% at the rate of 12%. So, this is a new argument, I've raised, that this argument was not placed before the Section 34 court.
Yes.
This argument was not placed before the 34 court, but this is a new argument. We say that the bills that were placed before the tribunal did not have the component of service tax when it was compulsorily to be taxed under the service tax. And therefore, those are procured bills. And with those bills of 2 months, you could not have given loss of profit for the entire period of 10 years. And more so, when the agreement said that you had to transport a good from one place to another and it was your goods. The agreement did not say that you could assign or carry those goods of other people. However, even if they had used those goods, there was no iota of letter or any correspondence to the railways that I want to transport, I do not have goods, but I can transport others' goods and earn profit. Why don't you allow me to do that? There is not a single scrap of paper from the side of the claimant before the tribunal asking them that I can earn profit. I may not have goods, but I can transport others because others may have
Argument
goods.
in fact for the first time in the 37 court.
No, this was raised, my lord. This is raised before
So
34.
it's a new point.
No, the service tax is a new point. Service tax is a point of law, my lord. So this is a new point. But other points were taken before the 34 court that they did not have goods, they did not file any documents to show that they can transport other goods. And with 2 months of goods, whatever they have said, there cannot be loss of profit for 10 years when there is no corresponding documents and when they have no goods. And when the agreement says that you have to carry your own goods. So these are the 3 points on that. But the third point is that, my lord, a lot of portion of the award, the tribunal has taken into the consideration of non-happening of the private siding. Now, my respectful submission is private siding is not a part of the dispute to the tribunal. Happening or non-commissioning of private siding is not a part of the dispute before the tribunal, but the agreement says so. Yes. Agreement 10.2 says, if the investor company requires own private siding, it will be governed by the relevant siding agreement in respect of the infrastructure facilities, including maintenance of wagons in the siding premises. So siding agreement is a different agreement. And that agreement was not before the tribunal and no dispute was raised on the ground of happening and non-happening of siding agreement.
Yes.
And my lord, the tribunal had spent a lot of time and had said that siding agreement, the siding was not given due to the fault of the railways, which was not a part of the dispute before the tribunal, which was again a contract which was outside the scope of the agreement. And my lord, that award should not, that basically that prejudiced the tribunal to award the contract also. But those are the 4 parts, and my lord, my lord, my counterclaim not being allowed. So my lord, these are the 4 parts, and my lord, my lord, Again, my lord, one more point, my lord, which Mr. Banerjee would have argued, but I will also argue. I argue that, my lord,
Mr. Banerjee would have argued.
yes, because Mr. Banerjee.
Oh, actually, Mr. Vikramjit Banerjee.
So I would have to complete this argument. So I will complete that because the supplementary notes were filed and my lord signed it over. The argument is that while granting compensation for the breach of contract, it is imperative to determine whether the party suffering the breach took any steps to mitigate its damages. And Section 73 of the Contract Act permits compensation for loss of damage which naturally arose during the usual course of things. It cannot be remote or indirect loss. So the profits that are earned due to rakes for third-party goods, the contract neither contemplates transportation of any particular type of goods nor contemplate assignment of the rakes.
আরো দু একটা পেন্সিল দিতে পারো কেটে দিতে পারো। ঠিক আছে ওটা দিতে পারো। So that is all.
So this is all, and my judgments.
Have you given us a compilation
Yes,
of
I have given.
judgments? Till now, you have not cited any judgment.
No, I have not said.
Why don't you make a compilation?
Well, the compilation is
Make an index. Topic, judgment. On what point you are citing?
একবার দেবেন। এই রে না ইয়েটা নোটসটা এইটাও না, এটা প্রথম যে বড় নোটটা দেওয়া যার মধ্যে জাজমেন্ট গুলো আছে। এটা ওদের আমাদের নোটসের সঙ্গে জাজমেন্টটা লাগানো আছে। But here in my notes, the judgments are there with the paragraph numbers, not on propositions. The propositions are there in my notes.
No, but then how do we know you have given, how many judgments you have given?
No,
31.
10 judgments.
10.
They had given about it. About 10 judgments.
Mr. Lahiri, give us a one-page note saying the proposition judgment.
Do that I will do.
Let's do that.
I will do.
Very well. Mr. Mukherjee, yes.
My lord, I will, my lord, take your lordship to the act, my lord, because it's a 37 from, my lord, a post, my lord, 2015 amendment, my lord, challenge.
We indicated that, yes.
My lord, that is, my lord, the principal point here, because now, my lord, we have several, my lord, judgments of the Supreme Court which go to the extent of saying that, my lord, number one, 37 is not like an ordinary appeal. 37, we are only concerned with whether 34 has been applied, my lord, by the single judge. And third, my lord, the scope, therefore, of 34, my lord, is more limited than, my lord, what it was before, and also under 34 compared to 34. So, my lord, just have a look at the act.
Hey, thou. Not a limitation. Yes.
Now, my lord, kindly come to, my lord, section 34 once, my lord, subsection 2. My lord, we are, my lord, really, my lord, concerned here, my lord, with, my lord, P. My lord, section 34 2B, my lord 2, the arbitral award is in conflict with the public policy of India. Now, my lord, kindly see, my lord, the explanation which was introduced, my lord, with effect from 23rd October 2015. Because earlier we had, my lord, the ordinance, then we had the act. Act related back to the date of the ordinance. Kindly have a look at this, my lord. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if the making of the award was induced or affected by fraud or corruption or was in violation of section 75 or section 81. My lord, this is not made out, my lord, before, my lord, most important, the section 34 court. My lord, therefore, my lord, it cannot be made out, my lord, before a 37. Now, my lord, second, it is in contravention with the fundamental policy of Indian law. Or three, it is in conflict with the most basic notions of morality or justice. My lord, this case is also not made out. What now, my lord, is, my lord, contravention with fundamental policy of Indian law. Kindly see explanation 2. For the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. So, my lord, really, my lord, one looks at the award and, my lord, one should be able to say, my lord, without going into, oh, this was the case, that was the case, this is what happened. My lord, that it falls foul of, my lord, the fundamental policy of Indian law.
Yesterday, we have delivered a judgment, yesterday, on this, on the scope of 34, 37, referring to these explanations.
Yes, my lord, I have, my lord, State of West Bengal versus Shambhunath Court. Is that the one?
No, yesterday, BBM.
Oh, this was, my lord, prior to that, 17 July, my lord, is also, my lord, your lordship's, my lord, judgment. Yesterday, your lordship's, my lord. My lord, I look at that.
BBM Enterprise.
Then, my lord, kindly, my lord, take explanation 2, which I was placing, my lord. For the avoidance of doubt, the test as to whether there is a contravention with fundamental policy of Indian law shall not entail a review on the merits of the dispute. And then, my lord, 2A, if it's a domestic award, my lord, there is no, my lord, international party involved. My lord, this, my lord, extra ground, an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. Then, my lord, kindly see the proviso. Provided that the award shall not be set aside merely on the ground of an erroneous application of the law or by reference. So, my lord, Limitation Act point, my lord, cannot, suppose it's an erroneous application. Section 21, 22 of Limitation Act ought not to have applied. My lord, no. My lord, the only exception is, my lord, apropos, my lord, fundamental policy of law is, my lord, if it is contrary to a decision which is a binding precedent. That's, my lord, Sangyong, I'll show, my lord. Now, my lord, kindly, my lord, we have filed a note, my lord, if your lordship take it, my lord, within half an hour, I'll be through. My lord, আমাদের নোটটা দেখুন নোটটা এখানে দেখান আমাকে একবার দেখিয়ে দিন তাহলে বলে দিন তো আমাদের কম্পাইলেশনটা রেডি আছে My lord, kindly take, my lord, the heading, my lord, after paragraph 4. The heading is scope of section 37. But it's a page 2, Miller.
Yes.
My lord, kindly see, my lord, scope of section 37 of the Arbitration and Conciliation Act. My lord, kindly come, my lord, to para 2, first sentence. My lord, two important facts here. My lord, award is passed. It's a reasoned award. Contract has been considered. Material placed before the arbitral tribunal has been considered. Now, my lord, clauses might have been interpreted in a particular manner. When the breach occurred might have been interpreted in a particular manner. Whether it was a continuing breach or not, my lord, has been examined in a particular manner. My lord, for loss of profit, there was evidence on record. Gambhir Mal's case, my lord, I don't need to remind your lordships, my lord. Damages can never be proved, my lord, with absolute certainty. There has to be a basis. There has to be a basis. It's not a unilateral contract which has been made applicable by Sangyong. My lord, there is a basis. There was a valuer who came and gave evidence as to what should be the price. My lord, because the wagons are taken over. My lord, I didn't get to use it for 10 years. It was kept, my lord, in the railways pool. So a compensation has to be paid. My lord, what would be the compensation? My lord, rolling stock transfer basis, my lord, was utilized. That valuer came, gave evidence, explained why it is so. My lord, no cross-examination on this. My lord, what is said is, if a wagon is condemned, damaged beyond repair, my lord, how it will be valued is how you should do it. Cannot be, because now, my lord, they have it, my lord, for, my lord, good to use. The wagons were never condemned. My lord, these are the kind of, my lord, things, my lord, which have been argued before your lordship. Now, my lord, here, my lord, when we come on appeal, my lord, by way of section 34, my lord, the learned judge, my lord, has, my lord, I will show the order, applied, my lord, the principles, my lord, of a 34 in assessing, my lord, whether the award should be set aside or whether it should be upheld. Learned judge, my lord, has, my lord, affirmed the award. Now we are on 37. So, my lord, keeping that in mind, my lord, I've given some of the cases which say, my lord, once it has been affirmed, even narrower, my lord, than, my lord, when examining, my lord, a 37.
As you said, Mr. Mukherjee, as I understand, scope of 37 is to see whether or not the learned single judge in 34 acted within the parameters of 34.
Now, my lord, I have, my lord, if your lordships kindly take, my lord, paragraph 2, first sentence of my note, page 3. It is well settled that scope of jurisdiction under section 37 of the Act is not akin to normal appellate jurisdiction. My lord, these cases I've given you, I'm not going to place all of them, but I'm going to place, my lord, Sangyong and one more. My lord. Then, my lord, kindly come to para 3. While jurisdiction conferred on courts under 34 is narrow, when it comes to the scope of an appeal under 37, jurisdiction of the appellate court is all the more circumscribed. Because the examination is of the learned single judge's order. Now, my lord, reliance is placed. My lord, I've given all these cases. My lord, kindly take, my lord, in the compilation, my lord, I have handed up, my lord, Sangyong, and my lord, I believe, simple question. I can look at it. My lord, kindly take, my lord, Sangyong first, my lord, which is at page 129 of the compilation. Is it in the note? My lord, kindly, my lord, take Sangyong, my lord, paragraph, my lord, 36 to 41. Which should be, my lord, it starts at 129.
Paragraph 30.
6 to 41.
168.
And open associate builders para 18 and 27. Now, my lord, kindly have a look at 36. My lord, at page, report page 170. My lord, running page 168. Thus, it is clear that public policy of India is now constricted to mean, firstly, that a domestic award is contrary to the fundamental policy of Indian law as understood in para 18 and 27 of associate builders, or secondly, that such award is against basic notions of justice or morality as understood in para 36 to 39 of associate builders, explanation 2 to section 34 2b2 and explanation 2 to 40. We are not as added was added by this only so that Western Gecko as understood in so and so was now done away with. Then, my lord, insofar as domestic awards made in India are concerned, an additional ground is now available under subsection 2A added by the Amendment Act 2015 to section 34. Here there must be patent illegality. Kindly note this. The language is, my lord, appearing on the face of the award, which refers to such illegality as goes to the root of the matter, but which does not amount to mere erroneous application of the law. In short, what is not subsumed within fundamental policy of Indian law, namely the contravention of a statute not linked to public policy or public interest, cannot be brought in by the back door when it comes to setting aside an award on the ground of patent illegality. This, my lord, very important. Then, my lord, secondly, it is also made clear that reappreciation of evidence, which is what an appellate court is permitted to do, cannot be permitted under the ground of patent illegality appearing on the face of the award. Then, my lord, to elucidate para 42.1 of associate builders, namely a mere contravention of substantive law of India by itself, is no longer a ground available to set aside an arbitral award. Para 42.2 of associate builders, however, would remain. For if an arbitrator gives no reasons for an award and contravenes so and so, that would certainly amount to a patent illegality on the face of the award. Then, my lord, 40. The change made by 28.3 by the Amendment Act really follows what is stated in para 42.3 to 42.5 in associate builders, namely that the construction of the terms of a contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in a manner that no fair-minded or reasonable person would. In short, that the arbitrator's view is not even a possible view to take. Also, if the arbitrator wanders outside the contract and deals with matters not allotted to him, he commits an error of jurisdiction. This ground of challenge will now fall within the new ground added under section 34(2)(a). Now, my lord, 41. What is important to note is that decision which is perverse, as understood in para 31 and 32 of associate builders, while no longer being a ground for challenge under public policy of India, would certainly amount to a patent illegality appearing on the face of it. Thus, a finding based on no evidence at all, or an award which ignores vital evidence in arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. Additionally, a finding based on documents taken behind the back of the parties by the arbitrator would also qualify as a decision based on no evidence, inasmuch as such decision is not based on evidence led by the parties, and therefore would also have to be characterized as perverse. My lord, this is, my lord, where, my lord, today we are, my lord, in the law, and my lord, its application, my lord, to my lord, 34. This is Sangyon. Now, my lord, kindly come to, my lord, we have this decision in the compilation 2024, not UHA. Punjab State Civil. Do we have it here? Punjab. These are the things, everything. Supposed to check. আসবে কি করে? Has anyone bothered? My lord, the decision which I wanted to cite, just make a note, I'll give it tomorrow, my lord, or my lord, 2024 SCC online, SC 2632. This is, my lord, Punjab State Civil Supplies Corporation Limited and another.
Page.
My lord, 2024 SCC online, SC 2632.
Punjab.
My lord, I find, my lord, luckily it's come.
দেবে না কপি দেবে
দিচ্ছি ওটা ইয়ে করে দাও, এড্রপ করে দেবে
না
কি?
আমার আমি আই ডোন্ট
কি করছো এগুলো? My lord, kindly see the point of determination, my lord, paragraph 8. My lord, kindly take para 8, my lord. The short question on the submission of parties which arises for our consideration is about the scope of powers of the appellate court under section 34 of the Act and whether the appellate court was justified in setting aside the award dated so-and-so, which had already, kindly mark this, which had already been confirmed under section 34 of the Act. This was the issue. Now, my lord, the object of the Act, my lord, legal position is discussed. The object of the Act is to provide for a speedy and inexpensive alternative mode of settlement of dispute with the minimum of intervention of the courts. Section 5 of the Act is implicit in this regard and prohibits interference by the judicial authority with the arbitration proceeding, except where so provided in Part 1. The judicial interference, if any, is provided inter alia only by means of section 34 and 37 of the Act, respect. So, my lord, overriding purpose, my lord, of the Act, statement of objects and reasons, my lord, to, my lord, ensure that commercial disputes, my lord, which are going before a private forum, my lord, are speedily decided. Now, my lord, kindly see the legal, my lord, para 10. Section 34 of the Act provides for getting an arbitral award set aside by moving an application in accordance with subsection 2 and subsection 3 of section 34, which inter alia provide for the grounds on which an arbitral award is liable to be set aside. One of the main grounds for interference or setting aside an award is where the arbitral award is in conflict with the public policy of India. That is, if the award is induced or affected by fraud or corruption, or is in contravention with the fundamental policy of Indian law, or it is in contravention with a plain reading of section 34 reveals that the scope of interference by the court with an arbitral award is under 34 is very limited, and the court is not supposed to travel beyond the aforesaid scope to find out if the award is good or bad. Then section 37 of the Act provides for a forum of appeal inter alia against the order setting aside or refusing to set aside an arbitral award under 34. The scope of appeal is naturally akin to and limited to the grounds enumerated under section 34. Then, my lord, it is pertinent to note that an arbitral award is not liable to be interfered with only on the ground that the award is illegal or is erroneous in law, that too upon reappraisal of evidence adduced before the arbitral tribunal. Even an award which may not be reasonable or is non-speaking to some extent cannot ordinarily be interfered with by the courts. It is also well settled that even if two views are possible, there is no scope for the court to reappraise and to take different view other than what is it. The view taken by the arbitrator is normally acceptable and ought to be allowed to prevail. My lord, it is, my lord, the, my lord, principle of non-interference. My lord, when we joined the profession, my lord, we had a Sanchoita bench. My lord, where, my lord, it was on, my lord, the person accused to prove beyond reasonable doubt that he wasn't enjoying Sanchoita funds. It was the other way around.
Was it Justice Probir Mujumdar's bench?
No, first was Justice Anil Sen, my lord. Anil Kumar Sen, my lord, was our Chief Justice, my lord. That was, my lord, the first. And then, my lord, A bench presided over by Justice Prabhu Kumar Majumdar came later.
Later.
Yes.
Court number 5.
Yes, it came later, but my lord, before Justice Sen, my lord, very few people escaped. Now, my lord, kindly take para 14. My lord, in fact, my lord, Bharat Coking, has it been considered? This case? Was it? Now, my lord, this case, I believe, which I'm citing, my lord, is not there in one judgment. I don't know if it's there in yesterday's judgment, my lord.
Which one?
My lord, the one I'm citing right now.
No.
Yes. My lord, this is, my lord, one of the later cases. In fact, my lord, Justice Narasimha now, my lord, is by and large taking, my lord, the arbitration court, my lord. Very pleasant, my lord, really pleasure, my lord, appearing before.
This is Justice Mittal.
I know, this is Justice Mittal, but my lord, Justice Narasimha's court, my lord, is
Very pleasant.
very pleasant. Then, my lord, in paragraph 11 of Bharat Coking Coal, which your lordships would have considered, I believe, my lord, at least in this judgment, it's there, State of West Bengal versus Shambhunath Ghosh, which your lordships have considered it. My lord, kindly see. Paragraph 11, my lord, which is set out from Bharat Coking Coal, may I just place it? Second sentence from para 11. When the arbitrator has applies his mind to the pleadings, the evidence adduced before him, and the terms of the contract, kindly note this, there is no scope for the court to reappraise the matter as if this were an appeal. And even if two views are possible, the view taken by the arbitrator would prevail. So long as an award made by an arbitrator can be said to be won by a reasonable person, no interference is called. My lord, Clapham Omnibus, my lord, comes, my lord, all the way, my lord, in this. In fact, my lord, that was the case, my lord, all the old cases, my lord, of a valuer, my lord, a valuation report, because, my lord, it's not an exact science. So, scope of interference is limited. Unless, my lord, a erroneous principle is applied, or, my lord, something which was material has not been considered. My lord, courts never, my lord, interfere. The final, my lord, arbiter, my lord, was the valuer. Right or wrong?
Wensbury unreasonable.
Correct. Wensbury unreasonable. Now, my lord, kindly see. However, in cases where an arbitrator exceeds the terms of the agreement or passes an award in the absence of any evidence, which is apparent, kindly note, which is apparent on the face of the award, the same could be set aside. It is equally well settled that now, my lord, this is where it is equally well settled that the appellate power under section 37 of the Act is not akin to the normal appellate jurisdiction vested in the civil courts, for the reason that the scope of interference of the court with arbitral proceedings or award is very limited, confined to the ambit of section 34 of the Act only, and even that power cannot be exercised in a casual and a cavalier manner. Then Diana Technology, my lord, is, my lord, referred to. Then, my lord, 16, it is seen that scope of interference in an appeal under 37 is restricted and subject to the same grounds on which an award can be challenged. In other words, the powers under 37 vested in the Court of Appeal are not beyond the scope of interference provided under section 34. Then, my lord, the other cases, my lord, are discussed, including, my lord, UHL power, and, my lord, which is there in the list, my lord, and kindly come to the conclusion at para 20. In view of the above position in law on the subject, the scope of the intervention of court in arbitral matters is virtually prohibited, if not absolutely barred, and that the interference is confined only to the extent envisaged under 34. The appellate power of section 34 is limited within the domain of 37 of the Act is limited within the domain of 34. It is exercisable only to find out if the court, now my lord, kindly, if the court exercising power under section 34 of the Act has acted within its limits as prescribed thereunder, or has exceeded or failed to exercise the power so conferred. The appellate court has no authority of law to consider the matter in dispute before the arbitral tribunal on merits, so as to find out as to whether the decision of the arbitral tribunal is right or wrong upon reappraisal of evidence, as if it is sitting in an ordinary court of appeal. It is only where the court exercising power under 34 has failed to exercise its jurisdiction vested in it by 34 or has travelled beyond its jurisdiction that the appellate court can step in and set aside the order passed under. Its power is more akin to the superintendence as is vested in civil courts while exercising revisionary powers. The arbitral award is not liable to be interfered unless a case for interference as set out in the earlier part of the decision is made out. It cannot be disturbed only for the reason that instead of the view taken by the arbitrator, the other view, which is also possible view, is a better view. It must be remembered that proceedings under 34 are summary and not like a full-fledged regular civil suit. Therefore, scope of 34 is much more summary in nature and not like an ordinary civil appeal. The award as such cannot be touched unless it is contrary to the substantive provision of any law, any provision, or the terms of the agreement. My lord, here, my lord, join issue slightly because my lord Sangyong has said it's not merely substantive. My lord, it overrules associated. It says, my lord, substantive provision of law which has a public policy element in it. Like, my lord, FERA. That's how Renu Sagar, my lord, the interference, my lord, was called for. That if it is contrary to FERA, FERA, my lord, is, my lord, to give effect to, my lord, public policy of conservation of foreign exchange. There's public interest involved. Therefore, my lord, in such a case, my lord, there was, my lord, interference called for. In the case at hand, my lord, it has not been found against power fundamental or in conflict with it to be. Therefore, award was rightly upheld by the court exercise. As such, could not have set aside the award without recording any finding that the award suffers from any illegality as contained in 34 or the court has committed an error. Merely for the reason that the view is a better view than the one is no ground to set aside. Now, my lord, kindly have a look. Now, my lord, I want to come straight away to the order of the learned single judge. Because, my lord, I'm saying, my lord, it's limited. One has to examine whether, my lord, 34 jurisdiction was, my lord, either not exercised or, my lord, was not exercised properly. My lord, that is, my lord, all that we are concerned with. Now, my lord, kindly take, my lord, the order of the learned single judge, one. My lord, which is, my lord, I'm told the appeal paper book. Where is it?
We'll follow the memo.
Very well, my lord. Memo. My lord, kindly give me a moment, my lord. I'll just find my.
Mr. Lahiri, your junior's name is also Mr. Siddharth Lahiri.
No,
Twice the name.
it's my name. I don't know why.
My lord, emphasis. Emphasis applied.
Because
my volume, maybe.
My lord, kindly come, my lord, to para 12. And, my lord, the judgment, my lord, of the learned single judge also very accurately reflects what was argued. So then your lordship will know, my lord, my learned friends being candid enough to indicate what matters were also not argued. So, my lord, kindly have a look at, my lord, first, my lord, para 12, heading is, my lord, limitation. The award debtor has argued that the notice issued by the award holder under section 31 is barred under article 113, read with 137, since the challenge to the impugned circulars were made after 3 years from dates of issue. The award holder, on the other hand, places the circulars which led the award holder to terminate the agreement on the ground of unilateral changes made to the terms and conditions of WIS and the orders passed by the Delhi High Court. The relevant documents would show that the respondent terminated the agreement in view of the petitioner making unilateral changes to so-and-so, so-and-so. These changes were in violation of clause 16, dated so-and-so, which provided that any change in terms While the petitioner claims that the changes were merely clarificatory, the respondent says changes amounted to amendments to circulars. The contentious issue on the nature of the changes was settled by a judgment delivered by a division bench of the Delhi High Court, which confirmed the judgment of the first court. Both these judgments held the circulars altered the basic structure of the agreement by modifying the essential terms and conditions of the incentives which were granted to the parties who had invested. The respondent terminated the agreement on so-and-so and followed it up by a notice under section on so-and-so after pronouncement of judgment of the division bench. Therefore, there is substance in the contention of the respondent that the judicial pronouncement by Delhi High Court declaring the impugned circulars amounted to modifications to terms was the cause of action for terminating. Termination was made a little over 7 months of the judgment, and hence notice under 21 cannot be held to be barred by limitation. It is also relevant that respondent's case was all along one of continuing breach, and the right to invoke arbitration arose only when the contract was terminated on so-and-so. The fact of continuing breach was taken note by the arbitral tribunal in the discussion on Article 55 of the Schedule to Limitation Act. The breach in the performance of the contract on the part of the petitioner award hold debtor was in the form of failure to provide freight rebate and failure to provide a guaranteed supply of rakes in accordance with clause 7.1. Agreement contemplates transaction between the parties to be in the nature of running and continuous action with a continuing obligation on the railways for supply of wagons. My lord, may I stop here? My lord, if wagons, my lord, were not supplied for a month, my lord, they got carried over. So, my lord, the preference got carried over, and it would get carried over month by month, which is, my lord, what is meant by the rolling account. My lord, it's a breach. My lord, you don't give it in 1 month, you have to make it up in the next month. You don't give it next month, that again, my lord, gets carried over. You have to give more. Now, my lord, section 22 of Limitation Act, which is relevant, envisages a continuing breach of contract where a fresh period of limitation begins to run with every act of breach. Terms of the agreement also show that the breach extended beyond a single omission and occurred every time when the railways refused to provide the benefits under the agreement to the respondent. The respondent's claims crystallized on termination, and its right to sue arose only at the point when contract was terminated. Then, my lord, it is also relevant to state that the respondent did not challenge the validity of the circulars, but only the applicability of such circulars to the respondent in view of clause 16 of the agreement, which barred the petitioner from incorporating unilateral changes to terms and conditions. By circular, prospective agreements, my lord, could be changed, had to follow that. But where I have an agreement which says any change has to be by mutual agreement, circulars couldn't, my lord, affect those. This is, my lord. It is also relevant to state that the respondent did not, but applicability, my lord, the last 3 lines, the objection of the petitioner in relation to its claims and were comprehensively dealt with by the arbitral tribunal. The section 34 court has a limited conspectus before it and a statutory bar on reappreciation of evidence. Since limitation is a mixed question of law and fact, the court is not inclined to interfere with the findings of the tribunal. The court also finds that there is no patent illegality on the part of the arbitral tribunal in deciding the question of limitation. The Supreme Court so-and-so curtailed the scope of an inquiry under 34 even further by declaring that a mere contravention of substantive law of India by itself will no longer be available as a ground for setting aside an arbitral award. Decision cited by the petitioner and so-and-so dealt with the purpose of section 21 of the Act and are distinguishable on facts. Present case is concerned with respondent section 21 notice, which the court finds to be within period. So, my lord, 34 issue addressed. My lord, even, my lord, substantive law, my lord, and its application by the arbitral tribunal addressed. My lord, with the greatest of respect, my lord, as far as limitation is concerned, there is no question, my lord, of, my lord, the learned single judge not having exercised his jurisdiction under 34 or having failed to exercise his jurisdiction. Now, kindly come to market value. Now, my lord, what happens? My lord, this was a 10-year, my lord, agreement. I could only use it for 9 months. Then I terminated and gave it back. My lord, if it had run its course, I would have also given it back. But I would have, over that period, enjoyed preference and allotment of wagons, as well as, my lord, a freight rebate, which other than 9 months, my lord, I did not. So, my lord, when I'm giving it back prematurely, my lord, I'm entitled to compensation. I could keep it or they could keep it. They chose to keep it. So they have to pay me, my lord. It can't be, my lord, free of cost. because I have bought the wagons and put it into the pool. This was to encourage, my lord, movement of cargo, this policy, my lord, and increase revenues, my lord, for the railways. My lord, both passenger and, my lord, freight traffic, my lord, are on the increase, which is a good thing. My lord, other countries, my lord, cannot keep threatening us. My lord, our internal economy, as a student of economics, my lord, will ensure, my lord, that whatever, my lord, we will be affected by whatever happens globally. But the impact will be cushioned because of the size of our economy. Unlike, my lord, various other countries who have a population of 1 lakh.
This is the world's biggest railway
Network. Biggest. And every railway budget for, my lord, either economic or political reasons, my lord, there will be an extension of a railway route. Has to be. And it's one of the largest employers. In fact, I don't know if your lordships would recall, Mr. Lalu Prasad Yadav, my lord, was invited to give a lecture in Harvard. And he went. And in his rustic style, with, my lord, an interpreter, he said, my lord, what good the railways, my lord, has done for the country. And, my lord, one of his main grounds, pitch for it was that it provides its largest employer in the public sector.
Must be.
My lord, not just direct employment, indirect as well.
Yes.
My
Correct.
lord, every tea stall on railway land, my lord, on railway land, my lord, provides livelihood. Even strays are looked after because of the railways. They are fed by the people who, my lord, stay in railway platforms. This is the reality of our country, my lord. My lord, when people, my lord, criticize, my lord, a lot of things, my lord, we have these as answers as well. It's, my lord, how one looks at it. My lord, half full or half empty.
Correct. I only wish that we could keep the bogies clean.
My lord, it's
That's all.
happening. My lord, it's happening in certain classes of trains. But, my lord, it's a massive thing. My lord, it's not going to happen overnight. And, my lord, like, my lord, we have a huge human population. We also have a huge insect population. We can't help it. Now, my lord, kindly have a look at, my lord, the next heading. Petitioner argues that the impugned award disregards the method of valuation stated in clause 11.2 of the agreement in arriving at the market value of rakes. According to the council, the method of assessment should have been depreciated value as per income tax rules minus the scrap value of wagons. Council submits that the tribunal ignored the terms of the contract in arriving at the calculation. Now, my lord, I pause here. Contract doesn't provide for any method of valuation. Now, my lord, counsel appearing for the respondent relies on clauses 11 and 12 of the agreement and the fact that even if the contract does not provide for a stipulated method of valuation, the claimant is entitled to value its claim based on customary methods of valuation. Clause 12 of the agreement provides for a scenario where the agreement is terminated by the investor due to any alteration in the scheme, whereby the ownership of the wagons would remain with the investor, the respondent in this case. This formula forms part of Chapter 7 of Volume 1 of the Indian Railway Financial Code published by the Railway Board, Ministry of Railways. Moreover, since the wagons were to be transferred to the railways, it was reasonable that the wagon should be valued as the railways would itself value the wagons when they transfer the same from one railway to another. It is also stated that when the contract does not provide a stipulated method of valuation, the claimant is entitled to value its claim based on customary methods of valuation of all market rates which are reasonable and fair. The fairness of the valuation which was done in the present case would be evident from the method used by the award debtor itself in connection with transfer of its wagons from one railway to another. Clause 11, relied on by the award holder, is concerned with wagons involved in accidents. Where the wagons are condemned as a result, railways pay a nominal value at the time of condemnation. Clause 11.2 has no manner of application since none of the wagons in the present case were involved in an accident. It is also significant that award debtor did not come with any suggestion, kindly note this, with an alternative method of valuation before the arbitral tribunal for arriving at the value. It is also correct that arbitral tribunal has final say on the quality and quantity of the evidence laid before it, and the referral court can only interfere in a section 34 application where the view is an impossible one. The proviso to 34(2)(a) makes it clear that an award shall not be set aside merely on the erroneous application of law or reappreciation.
3.5 minutes.
Yes. My lord, kindly take page 9, my lord.
Yes.
The award on account, kindly see the heading again. This is the third point. The award on account of loss of freight rebate was in disregard of the evidence available before the trial. The petitioner award debtor argues that allowing the claim for freight rebate was in ignorance, disregard of the evidence, and that the award holder did not load any rakes under the so-and-so even after commissioning of the siding. The respondent relies on Section 73 of the Contract Act for the damage suffered on account of termination, and that the petitioner was stopped from challenging the validity of the grounds on which the respondent terminated the agreement. According to the respondent, the only question which remained was the quantum of damages which was to be awarded in favor of the respondent by way of compensation in terms of 73, since the respondent was unable to utilize WI's rate during the negotiable period of the contract. Counsel submits that the respondent, as the owner of the rakes, was entitled to a freight rebate of 10% on 6 rakes per month for 10 years. Of the total span of 7 years and 6 months from the date of commissioning of the rakes till the termination of the agreement, the respondent was allowed to avail WI's facility only for 9 months and was deprived of the facility for the balance period of 6 years and 9 months. Hence, the respondent was constrained, kindly mark this, to place indents for regular rakes to fulfill its iron ore consumption and register at different railway sidings, which led to loss of freight rebate of 10%.
That makes sense.
Now, my lord, kindly see the rebuttal of the award holder. Respondent consists of admitted facts. The termination was before the end of the end time of the agreement, that is before the respondent could avail of the full benefit of the agreement of so-and-so. Therefore, the respondent's loss of rate rebate of 10% under so-and-so is factually correct. It is also admitted that the award debtor did not put any meaningful question or suggestion on the respondent's claim for freight rebate at the time of cross-examination of the respondent's witness. There was no cross-examination on the respondent's entitlement to the claim of freight rebate or the claim amount. Hence, the respondent's evidence of the claim and quantum remained unchallenged. Therefore, the arbitral tribunal cannot be said to have faulted in relying on the evidence of the respondent's witness in this regard. It is also relevant to state that the letters relied on by the petitioner, including of 29 January, 8 April, 1st August, and 16 September 2013, did not state that the respondent had no goods to transport. Moreover, the respondent had adduced evidence before the arbitral tribunal that the respondent had transported substantial quantity of goods between December and June by disclosing more than 900 railway receipts, out of which more than 300 railway receipts belong to the period from January 2013 to 17 June 2016, the date of termination. This is the material on record. Then, therefore, the petitioner's argument that the respondent did not place any rakes is factually without basis. The arbitral tribunal also found that the award was prevented from loading so-and-so by the petitioner on the ground of non-mentioning of the designated loading station due to lapses on the part of the petitioner itself, and that the respondent could not benefit from so-and-so after April due to unilateral changes made by the petitioner. This court does not find any infirmity in the tribunal's finding of the respondent to claim for freight rebate, also in view of there being no cross-examination in respect of respondent's claim or the quantification thereof by the petitioner. My lord, this shows, my lord, mind addressed. Tribunal had addressed its mind, my lord, to what was before. And, my lord, the documents, my lord, which are relied on do not show, my lord, that there were no, my lord, freight available, which they say were not taken into consideration. My lord, it has to be material to make a difference to, my lord, the finding. My lord, every, my lord, correspondence exchange, my lord, need not be gone into, my lord. It's a never-ending process. Then you take one letter, this says this is the evidence on this. My lord, this is a holistic view, my lord, which has to be arrived at. My lord, by, my lord, this evidence, my lord, which has been specifically referred to, would, my lord, the finding have changed? Was it material in that sense? Would it have negated any finding which has been arrived at? If I may, my lord, ask the question to myself. Now, my lord, kindly come to, my lord, the next heading. The award on the respondent's claim for loss of profit was in disregard of the wagon investment scheme policy. Counsel appearing for the petitioner argues that the arbitral tribunal disregarded the fact that the goods which were to be transported, goods which were to be transported by the WIS regs were solely for self-consumption of the respondent, and arbitral tribunal should not have relied on agreements between the petitioner and SESAGOA for allowing the claim for loss of profit. On the other hand, counsel appearing for respondent argues that the respondent, now kindly note this was not argued before the arbitral tribunal. It comes in, my lord, in a 34. On the other hand, learned counsel appearing for the respondent argues that the respondent did not raise this issue before the arbitral tribunal.
Petitioner did not raise this issue.
Correct, my lord. The section 34 petitioner had not raised this issue before the arbitral tribunal. Argues that they did not raise this because what was argued was SESAGOA is irrelevant because you had to carry your own material from point A to point B. Therefore, SESAGOA should not have been relied on. But before the arbitral tribunal, my lord, this point had not been argued. Now, my lord, it's argued here. Now, kindly see how it's dealt with. On the other hand, counsel appearing, para 33, my lord, appearing for the respondent argues that the respondent did not raise this issue before the arbitral tribunal and has only taken this point at the time of argument. Counsel submits that the agreement dated so-and-so contained the mandate of so-and-so should only be used for self-consumption and not for commercial dealing with parties. Hence, the tribunal's award of loss of profit on respondent's agreement from SESAGOA is correct. It is undisputed from the evidence on record that there was no cross-examination by the petition of respondent's witnesses on the claim for loss of profit. In the absence of such, the evidence of so-and-so remained unchallenged and has to be taken into consideration. The arbitral tribunal's decision in respect of the claim for loss of profit is clearly discussed in the impugned award with reliance on annexures and invoices raised on SESAGOA. The impugned award is based on evidence which is uncontroverted and the court is not inclined or even statutorily authorized to interfere with the tribunal's findings on the evidence. Kindly note this, my lord. Although the petitioner has relied on associate builders and PSA SICAL on the point of perversity where the award is not based on evidence or takes into account extraneous facts or ignores vital evidence, the impugned award in the present case is replete with findings on oral and documentary evidence which was before the arbitral tribunal. Now, my lord, kindly see, my lord, private siding issue, which he says was beyond the scope. The impugned award deals with a dispute which falls outside the term submission to arbitration. Learned counsel appearing for the petitioner submits that the issue with regard to delay in construction of private siding at Borojamda was not part of the notice issued by respondent on 3rd October for invocation. Counsel submits that arbitral tribunal went beyond the scope of the reference and returned a finding in that regard. Now, my lord, actually, they raised it as an issue to justify their conduct. It will appear here. Learned counsel appearing for respondent relies on an in-principle approval of the railways of 6 February to the respondent's application for setting up a private siding at Borojamda and a letter of 6 May 2007 of the Railway Board accepting the respondent's proposal to induct 2 rakes and 2 brake vans. Council also relies on a letter of 5th September whereby the railways confirmed having received 2 rakes and clarified that the said rakes were to be inducted in the future construction of private siding of the respondent. Then, my lord, kindly see. The impugned award shows that the respondent successfully demonstrated before the arbitral tribunal that the petitioner's breach and defaults of the agreement resulted in the non-commissioning of the private siding at Borojamda, and further that the respondent was directed to utilize an alternate siting for 9 months out of the contractual period of 10 years. It would further be evident that the petitioner cited delay. Kindly note this. Petitioner, that's the section 34 petitioner, cited delay in commissioning of the respondent's claimant's private siding at Borojamda as one of the primary reasons for the petitioner's refusal to grant the claimant's entitlements under the WIS. They made it. You have not set up a private siding. Then, therefore, the reason for the private siding at Borojamda not being commissioned on time was a crucial dispute which went to the root of the differences between the parties and was wholly within the scope of the arbitration agreement. Hence, there is no basis to the petitioner's stand that arbitral tribunal acted beyond the contemplation of the reference or arrived at a finding which was beyond the scope of submission to arbitration. Well, they say termination wrongful. They say you could not take advantage of WIS. You therefore cannot claim damages. And the reason for this is you did not construct private siding on time. Now, my lord, who was at fault for delay in private siding is squarely in issue then. And at their instance, to deny a claim, my lord, under my lord, the my lord, WIS contract, breach of contract. Now, my lord, kindly see rejection of petitioner's counterclaim is perverse. Contrary to the stand taken on behalf of the petitioner's counterclaim was not based on any evidence and the tabulation contained therein was also not proved. The petitioner did not lead evidence on whether the rakes which were to be allotted to the respondent were lying idle during the corresponding period or whether the petitioner had actually suffered in the loss for the alleged non-placement of indents by the respondent. Then, my lord, in any event, the petitioner also failed to rebut the objection raised by the respondent to the counterclaim and hence failed to discharge the onus cast on the petitioner to substantiate the counterclaim. The impugned award on this score cannot be interfered with for the aforesaid reason. Now, my lord, one very simple, my lord, point here. My lord, these rakes are in the railway pool. My lord, if I don't, my lord, assuming, my lord, I do not, my lord, place an indent, my lord, which I could have, let us say, or my lord, I, my lord, don't have cargo, my lord, to, my lord, send it. Whether my own or somebody else's, I don't have. My lord, the rakes are, my lord, the wagons are with the railways. My lord, no wagon ever lies idle as far as railways are concerned, because otherwise they are entitled to use it. For them to prove loss and make a counterclaim, my lord, would have been almost impossible, because they would have earned freight. Unless they said, my lord, we could not earn freight because there was no freight. Nobody, my lord, can say that, my lord. Now, my lord, kindly come to para 39, my lord. The court will not interfere with a plausible or even a possible view as long as the view taken is not perverse. The court will only substitute its view if the award contains findings which are ex facie perverse or impossible on the face of the record or the evidence which was before the tribunal. The petitioner has not produced any evidence of the arbitral tribunal ignoring vital facts or taking into account irrelevant facts or pronouncing on an issue without any evidence. None of the grounds available to an aggrieved party to seek recourse under 34 has successfully been raised before this court. The ground of perversity can only be accepted where the arbitral tribunal has arrived at findings or conclusions which are not supported by evidence or were entirely beyond the contemplation of the reference. Above reasons persuade this court to hold that there is no scope for interference in the challenge to him is dismissed. So, my lord, in my respectful submission, my lord, when, my lord, examining, my lord, when deciding this appeal, my lord, the first, my lord, application of mine, my lord, has to be to see if the learned single judge, my lord, exercise, my lord, the jurisdiction under 34 correctly. That is the real, my lord, limit, my lord, of, my lord, the scope of inquiry. And, my lord, with the greatest of respect, my lord, what was argued, my lord, before the learned single judge, my lord, on that basis, my lord, it is evident, my lord, that, my lord, section 34, my lord, was, my lord, complied with. The jurisdiction exercise was within the parameters, my lord.
Naturally, what is challenged before us is the learned single judge's order, not the arbitral award.
Correct.
So we'll have to see if there's an error in that order.
Correct. And this is, my lord, which is why I feel, my lord, almost, my lord, every, my lord, 37 which comes before your lordship, my lord, rather than go to the award first, my lord, it's the, my lord, 34 court order. Then, my lord, from the 34 court order, my lord, show, my lord, that what was challenged, the challenge was within 34 and has not been dealt with or dealt with wrongly. Because at the end of the day, my lord, your lordships are an appellate court, my lord. Now, my lord, if your lordships, my lord, kindly go back to my note. এটা তো করছে কিন্তু হবে না। The nature and scope of the arbitral award, my lord, is, my lord, indicated. What has been allowed, what has been, my lord, not allowed. Then, my lord, on scope, page 21, my lord, I've cited Sangyong, my lord. I think, my lord, it's still, my lord, the, my lord, best case, my lord, for, my lord, irrespective of PSA, SICAL, etc., my lord, which have followed. And of course, Hindustan Construction, they are all there. And then, my lord, each of the challenges, my lord, has been, my lord, dealt with. That's the, my lord, format. My lord, may I cite, my lord, just one, my lord, not on, my lord, the scope of 34, but, my lord, one of the earlier decisions, my lord, about this formula, my lord, which was applied, my lord, to assess damages. My lord, it's not mentioned in the agreement. There is no formula covering, my lord, this kind of, my lord, compensation. So, my lord, what could a formula have been used at all or not? My lord, here, my lord, volume, kindly take, kota ache, how many do you have? Yes. My lord, kindly take volume 2, my lord, of, oh, page 3, 4, 5. My lord, McDermott's case, my lord. My lord, in Hudson's building contracts, my lord, there are several formula given, my lord, on the basis of which damages are to be assessed. Here, my lord, there was a formula, the railway's own book, that if we have transfer from Western Railway to Southeastern Railway, how will the value be shown? My lord, that's what had been used. Now, kindly have a look at, my lord, the challenge, my lord, to using of a formula. My lord, paragraph 106, which is, my lord, page 384 of the compilation, and, my lord, print page 40, my lord. কি আছে তোমার আছে দিয়ে দাও না একটা কপি দাও আরে কি হচ্ছে কি take them out, you have to give to the other side also. তোমায় দিয়েছি কম্পাইলেশন দিইনি আমি দিচ্ছি তোমাকে দিচ্ছি my lord, kindly take, my lord, paragraph 106. In fact, my lord, I should, my lord, start with, my lord, paragraph 10, my lord, 5. Achhe. Before us, several American decisions have been referred to by Mr. Dipankar Gupta in aid of his submission that the Emden formula has since been widely accepted by the American courts, being so and so, so and so, so and so. Para 106. We do not intend to delve deep into the matter, as it is an accepted position that different formula can be applied in different circumstances, and the question as to whether damages should be computed by taking recourse to one or the other formula, having regard to the facts and circumstances of a particular, would eminently fall within the domain of the arbitrator. So, my lord, if there is an error, my lord, it's an error within jurisdiction. My lord, in terms of, my lord, constitutional law, my lord, Anis
Minnick. Anis Minnick was 1965.
Yes.
65.
My lord, and then we had, my lord, our grounds, my lord, in the writ in excess of or without jurisdiction. this is what I wanted to show, my lord. It's, if your, my lord, lordships are looking at, my lord, scope of 34, my lord, I'm not citing them, my lord. Your lordships are aware, my lord, it's all cited here, my lord. Just kindly take them to be cited. Then, my lord, kindly have a look at, my lord, page 22. My lord, I've done it headwise. Kindly see, my lord, limitation. And my lord, straight away, my lord, kindly come to clauses 12 and 13 at page 26, my lord. 12, 13, 14, 15. My lord, the conclusion, the question of limitation is a mixed question of law and fact, has already decided this issue on the basis of appreciation of facts. Stated that is an application under 34 would not reappreciate, which is required to. There is no patent illegality by the arbitrary determination of question. Moreover, in Sangyong, para 39, Honorable Supreme Court has clarified that a mere contravention of substantive law of India by itself is no longer a ground available to say. A decision on limitation by the arbitral tribunal is a decision on substantive law, and thus even if the railway's contentions were correct, the same would not be a ground to set aside. Before the learned single judge, railways relied on the judgment reported in so-and-so for the proposition. That purpose of section 21 is to determine date of commence for deciding whether claim are barred by laws. The respondent has no quarrel with the ratio of the judgment. In the present case, has already submitted in the aforementioned claim was not barred by laws of limitation on date of. Hence, the judgment cited have the finding in regard to. I mentioned, my lord, the paragraphs which I just placed, my lord. In fact, now, my lord, even for a section 11, my lord, the little bits which were open, my lord, in Vidya Drolya, my lord, all that has gone now. Now it's only arbitration agreement. That is all. Whether barred by limitation or not, no matter how bad the case is, you still refer it. Because this is a job of the arbitral tribunal, not of the court. Even that has gone. Earlier, my lord, we talked about life claims. We talked about, my lord, ex facie barred by limitation. All that has gone now. গেছে আমি জাস্ট সাইট করলাম 4 দিন আগে উড়ে গেছে পার্টিওয়ালা 25 হ্যাঁ পার্টিওয়ালা
25 অবধি ছিল লিমিটেশন
না না ছিল
মিডল অফ দি
eye of the needle has gone now.
আই অফ দি
Then, my lord, market value issue, my lord, is also here. My lord, I'm just showing your lordships, my lord, so that I can go quickly. I'm sure your lordships will, my lord, read it. Then, my lord, respondents reply. And, my lord, page 29, I have, my lord, referred to McDermott. 29. McDermott যেখানে আছে দিয়েছে তো কপি my lord, then, my lord, disregarding evidence, my lord, even that is dealt with.
Mr. Mithru, you can go because 12:45, we didn't remember. We were reminded matter has been fixed at 12:45. Next one, 12:45, learned councillor here.
My lord, I can conclude now for today and do it tomorrow, my lord. Mr. Mitro's here. I didn't know he was waiting.
12:45, you're for?
I'm led by Mr. Ronald Chudhary. He's outside.
Oh, this is that, yeah. This is that. Coke, mate Coke.
Bengal in a way.
Oh, Bengal.
Last option we filed the valuation report.
Very well. So it means the matter will be taken up. Right, very well. So Mr. Mitro can go because Mr. Mukherjee will continue till 12:45. Second half, it's a different bench today.
Different bench, my lord.
Then it goes on to Monday.
Monday.
Monday for that. Kindly make it Tuesday.
No problem. Your junior will be here. Yes, no problem.
Like Tuesday or Wednesday. Monday can happen.
Whatever.
My lord, I'll require 10 minutes on Monday, my lord. 15 minutes. Just to, my lord, I'm rushing through this, my lord. Then, my lord, the next point, my lord, is dealt with, my lord, at page 30, disregarding of evidence. And, my lord, your lordship will find that, my lord, the award portions, my lord, have been marked out, my lord, in, my lord, each note, my lord, where the, my lord, in the paper book, where your lordship will find the award, where this has been dealt with. My lord, page 30 was, my lord, loss of freight rebate claim, my lord. Yes. My lord, 32, my lord, we have also mentioned, my lord, the 900 railway receipts, your lordships will find, my lord, subclause 7. My lord, page 32, my lord. And, my lord, your lordships kindly come to, my lord, paragraph 65 of the arbitral award, which is at page, my lord, 53 of the award, my lord. Huh? No, what is this 53? Oh, page 47 of the award. Award to the Chonadam. My lord, it's at page 2060 of, my lord, arbitration paper book, volume 7. Lordships have the award separately, my lord. My lord, then para 65, internal page 47.
Of the award.
Yes. My lord, that's there, my lord, in volume 7 also.
2060.
2060, my lord. My lord, kindly take, my lord, para 65. Your lordships have that, my lord?
Yes.
My lord, kindly see on the question of non-placement of indents, S.K. Biswas alleged in response to question 233 during cross-examination that railways have suffered from earning a sizable revenue for not receiving the indents for the rakes to be loaded as per WIS policy. Quantum of loss has been shown in the counterclaim. On the other hand, Mr. Sanjay Mitro CW1, while replying to question 64 during his, frankly admits that only during 9 months when railway gave them permission, the claimant registered indent for veiling of rates. On the procedure for placement of indents, he has further clarified in response to question in his cross-examination that for placement of indents, they had to approach the station manager or goods office who would register. As a customer, they did not get any receipt. In response, as clarified, the usual practice of railway not to issue any receipt acknowledging placement of indent, but a money receipt is issued by railways against deposit of indent, and that is the receipt is utilized in subsequent indents, and in some cases, money is adjusted against rail. As a result, such receipt is not in their accounts. It is also gathered from his reply to question so and so that railway as well as other are available in volume so and so. Again, while answering question so and so, it made clear by deponent in his cross that respondents have never allowed them to register indents under beyond 9 months period, and further that they had regularly applied before railways for registering indents for availing of rakes under WIS. However, the railways did not permit them to do so. Witness produces 11 documents, copies thereof served on the respondents and respond to so and so in his cross-examination. And these documents are marked so and so at the stage on the undertaking that will produce the origin. CW1 was further asked on the part of the railways in question 54 during cross-examination as to whether issuance of circular takes away the right of the claimant company to place indents for availing of guarantee. In response to such pointed question, the deponent frankly admits that placement of indent was not commercially viable to register so and so. In response, it categorically asserted by him that except for 9 months, which he has referred to in answer to, they could not place the, since no permission was accorded by the railways. Be that as it may, the fact remains that consequence upon issuance of diverse circulars, the WIS policy was severely impacted, causing serious prejudice to the interest of claimant, and due to such unwarranted compare, the claimant had to terminate in question the placement of indents in terms of appears to be more so whenever entitlement of benefits has been denied to the claimant because of fundamental change in WBS so and so. Then Millard. And Millard, kindly come to now Millard para 94. That's not correct. It's wrong. Ninety-four of what? Yeah. Millard, kindly take internal page 74, paragraph 94, Millard, which is at page 2087. Lordships have that.
Shall we continue on Monday?
Yes, Millard, this is Millard, the final conclusion which is arrived on freight rebate.
Mr. Mukherjee, Mr. Lahiri, from a learned counsel representing the appellant, concludes his opening submission. Paragraph, Mr. Mukherjee, from a learned senior counsel.
We had 2 Millard, 2 o'clock.
Monday. Yes. Monday original side is first and commercial is first. You're in difficulty on Monday.
Millard, kindly keep it at Millard 1 o'clock. Millard, I'll finish in 15 minutes. So this.
So then we'll keep it at 12:45. You can finish off with your reply also.
Reply. I have to see if any new judgments are there. I will try.
Yeah.
12:30 something is fixed. ঠিক আছে 1 o'clock এটা রেখে দাও এটা তো 15
মিনিট I can conclude then.
Mr. Mukherjee, Kamal senior counsel representing the respondent oblique award holder begins his argument but does not conclude. Paragraph, as requested by Mr. Mukherjee, let this matter be listed again on Monday date the marked 1 p.m. Or would you rather come back at 2 p.m.? 2 is all right for you, know.
তোমার জন্য বেটার আমার অন্য জায়গায় মামলা আছে হ্যাঁ ঠিক আছে
or even later at the end of the day as you wish.
2 p.m. I can come then the matter will be
later 12:45 at 2 p.m.
मंड्यामध्ये किती आहे?
আচ্ছা তাই কাজ করো না এটা আইপ্যাড কেন ওল্ড স্কুল ঠিক আছে এত কাজ সামলাবে কি করে পেপার তো
এতে পড়তে পারি না জাজমেন্ট কি পড়তে পারি I know.
দেখো 12:45 টা রেখে দাও
Commercial bill. Scientific like number 23.
Millard, there's a report, Millard. I have checked up the report, Lordship. Millard, there are two valuations given, 2014, 2023. I am out of pocket in 2013 itself, Millard. That's recorded in the order. My rights have accrued in 2014 because of Justice Patheria's order, Millard. Whatever right I have. There's a report which says a valuation of 2014 and 2023. The Lordship has to, Millard, see, Millard, the valuation which I get because I'm out of pocket for this entire fund, Millard, before 2014. But I cannot go, Millard, before 2014. The order is of 2014, Millard. So what I will get, because land prices have gone up, the money value has come down. And without any fault of mine, Millard. I was there, he did. Something happened, official liquidator, Millard, did not give me the plot of land. Today, Millard, there is, Millard, chunks of lands, Millard, he has demarcated. But Millard, he has to give me, Millard, land together. Millard, some land here, some land there, some land, Millard, in front, Millard. It doesn't benefit me. It doesn't benefit me, Millard. So he has to take that view, what he wants to give me. Date Lordship can decide. Dates Lordship can decide. 2014 or 2011, my argument will be 2011. Because I'm out of pocket in 2014. 2014, I stand corrected. 2014.
My lord, if your lordships kindly
ছবিটা আছে একটা ছবিটা দে তো ছবিটা দেখি হয়ে লাভ হয় না সবাই মিলে লাফিয়ে উঠে পড়ে
if your lordships kindly see the order of this
briefly what are the facts Mr. Bratkush?
Millard, there was a company by the name of Bengal.
Yes.
The Bengal Enamel went into liquidation in the year 1984. There was an application for the bank, Millard, for Millard winding up. Now, Millard, I was invited by the promoters to put in the fund to save Millard to take it out of the winding up or what to pay the dues of the bank. I paid directly to the bank. Millard, time to time, total amount was supposed to be paid 450 crores. For 4.5 crores, I have paid Millard 2.25 crores. Till Millard 2013, from time to time, 2006 to 2012. Now, Millard, in the meantime, Justice Patheria's order, in the meantime, the bank left all, bank has got their money. That's recorded in the order itself. Justice Patheria's order is there saying that since I have not paid the entire amount, the value of the land aggregating to 2.25 lakhs will be given to me in 2014 itself. Well, nothing done. Letter of direction taken. Justice Sinha in 2017 says absolutely clear. You can sell 7 except that land in question. Value of 2.25 lakh. Millard, thereafter the matter comes back. One of Millard, the promoters filed, Bhamani Shankar Ganguly files, saying that please take out disclaimer on the Millard leasehold land because this belongs to the family, not the part of the company's asset. Disclaimer allowed. So I am left with Millard, whatever land is today, Millard. Same day, Millard, the application appears before the Honorable single judge. He, Millard, dismisses my application. He recalls the order of Justice Sinha and also, Millard, I filed a recalling for that because some way it was protecting me, 7 except. That application also was dismissed, Millard. Saying infructuous. Against that, Millard, and you take back money by taking regular civil course. What course I will take, Millard? If a company is in liquidation, I have to be before the company.
You want the land now.
I want
worth
the land now.
2.25 crore.
What is
Question is as on what date? Valued at what?
What date? 14, I'm out of pocket. Not that I have not paid that sum. And he has given এইটা কোনটা দিয়েছে দেখা
But
he is getting, my lord.
yes, now Mr.
He has
Chaudhary.
given me this L. With the L, what should I do, my lord? He's saying you take this L 2014, and what should I do with the L? Look at what he has given.
Good. Can you identify continuous?
Yes, I can identify continuous land. Let the joint inspection be done. Because Lordship has to take a view on the valuation also.
There was an order on 6th February 2024 by the Honorable Court of Appeal, my lord, by which, my lord, the official, it was directed in the circumstances, we direct that the land be surveyed and demarcated, showing the extent and description of the land, taking the value of rupees 2.25 crores as on 25th September 2023, and also a separate demarcation showing description and extent of the land valued at rupees 2.25 crores in 2014. So, my lord, the valuer has done both.
Right. We will decide whether it's 2014 or 23.
Yes, my lord, if your lordship kindly turns to page 7 of the valuation report, my lord, here it is written, there are two kinds of land. One is, my lord, the freehold land.
আমার এই আঙুলটা কি বলবো ভীষণ ব্যথা।
আমার মানে ওয়ার্কার্সরা আছে, কি করা যাবে ওখানে এনক্রোচ করে কোনো ফ্রি ফ্রিহোল্ডটা
তুলতে গেলে
কিছু জায়গা আছে যেগুলো ওয়েল বিক্রি করবে না,
কিছুটা একসঙ্গে দিন। My lord, I have got an application today, ACO 4 of 2025. My lord, we are the residents. We are from the last 50 or more than 50 years, we are residing in the quarters built by the company. There are altogether 1,000 kathas of the land. Some are the freehold, some of the leasehold.
37 kathas.
Your application has been listed today?
Yes, lordship.
Yes. I am to get, my lord, 37 kathas of land. If it is 2014 valuation.
37
at
kathas.
the highest.
2014 freehold, 37
You
kathas.
may not be affected by that.
No, my lord, because my lord, if your lordship kindly take my application, when the joint survey was done sometime in the year 2014, we were directed to present there. The registered Sumiti, altogether all the members of the residing residents, and we, before the official liquidator, if your lordship kindly take my page 54 of my application.
Key application?
Addition of party.
How can the worker be party to my application?
No, my lord, why?
No,
My lord,
he has no right of hearing. Kindly don't hear him.
On what basis are you occupying?
Lordship, kindly take my application one.
Why don't you tell us, sir?
Yes, lordship, my lord, before the official liquidator, the secretary of the Bengal Enamel Nagor South Nagorik Unnayan Samiti and the inhabitants of the leasehold cooperative, the representative of official liquidator, at the time of obtaining symbolic possession the subject property, he submitted that they are staying at the place for the last 50 years, and ex-employees have claim in the respect of the company in liquidation in arrear salary, bonus, gratuity, leave salary, etc. He also requested the representative of the official liquidator to submit before the honorable court for considering their residential status at the subject premises. My lord,
what is your right?
My lord, we are residing in the quarters.
What is your right to reside there?
My lord, we are the heirs and the successors of the ex-employee.
That gives you a right, legal right.
No right. My lord, the Ganguly family, Ganguly, the promoter of the company, took the rent.
Millard,
took the rent from us.
Millard, I do not know, Millard, whether the worker, Millard, can claim any right to the companies, Millard, land, Millard, and companies, Millard.
Has he given you a copy of the application? Do you know?
No copy of this has been served.
Serve it.
Lord, I shall serve. Today itself,
the quarter, Millard, he has a right on leasehold land. He has no right of hearing.
Yes, what were you saying?
My lord, your lordship, kindly see, my lord, page 7 of this report.
Page 7.
Yes.
This is the leasehold area of the land shown 3.15 acres. This land was handed over by the official liquidator in pursuance of these orders of this honorable court to the, my lord, the lessor. Because he has made a disclaimer application, that order was passed and this leasehold land was handed over to the, my lord, the lessor. Now, my lord, kindly see page number 8. That is the freehold land in Mauja, Polta. 5.77 acres of land, page 8. That is freehold land. And my lord, another freehold land is Chandan Pukur, 1.16 acres. So total freehold land is 6.93 acres. That is page 11.
Almost 7 acres.
You on board 7 acres.
So,
Now, my lord,
so this 7 acres is 21 bighas.
Yes.
Almost.
Yes.
Which means Katha will be 420.
Yes, my lord.
So out of that 37 you can't give.
No, yes, yes, my lord. Kindly see then, my lord, page 15. The land value as of 2014. My lord, as per the directions of this honorable court dated 6th February 2024. My lord, page 15, my lord, land value shown as 2.25 crores and land area 2650.86 square meter. That is 39.63 kathas. That is my lord, the page number 18 as of 2014. This valuation, my lord, and the area of the land as demarcated can be given.
Page 18 Miller is the calculation.
Calculation.
Page 18.
Page 18. Page
15 বলছেন কেন?
No, no, 15 তো লেখা আছে, land value টা দেওয়া আছে।
You have to give it together.
Then, my lord, page.
He cannot give him chits and bits.
Then, my lord, kindly see, page 28 is as of 23. The valuation was land area demarcated 1280.95 square meter. That is 19.15 kathas as per valuation of 2023. Now, my lord, my submission would be, my lord, for the benefit of the creditors in general, your lordships can take the decision whether the official liquidator handover as per valuation of the 2013, 14 or 2020.
Very well, we will decide that.
Yes.
If we decide that it's the 14 valuation
Yes.
and 39 kathas should be given to 37, whatever.
37 kathas.
Is there such a continuous plot of land?
Yes, because there are, my lord, excess land also which is required to be sold. So
then what is the problem? He says there is.
Millard, there is Millard, not continuous. Millard, kindly look Millard what he is giving me Millard. That's the map. এই ম্যাপটা দিচ্ছে তো এইটা তো এইটা Millard lordship sees Millard, this is the L, this Millard page number, এই পেজটা কত? 19. Page 19 if your lordship
of the report.
Yes, he is giving me this L-shaped one.
My lord, the deed number has been mentioned.
Yes, tag number.
Number 7, my lord.
1758.
Yes.
Tag number 1758.
Yes. Yes, it is 1756. 1756 and 1760. Millard in between Millard. I just Millard indicate and give.
Not 1758. No,
Budget.
X. If your lordship kindly turns to page 15. Demarcation has been given, plot number has been given.
I just ticked it.
And thereafter,
this is what he is giving.
Where is this land?
Millard in Polta.
Polta and Chandanpur.
And Chandapur. This is the L stretch Millard I have ticked it. He is giving me. I have Millard checked up Millard with the tag numbers.
My lord, if your lordship kindly.
He has to give me Millard some Millard continuity. I'll make
Millard on the basis of the deed, my lord. This description has been given.
If it's not available, what can we do, Mr. Ghosh?
My lord, your lordship kindly turns to page 15, my lord.
Kindly,
number
it's
has
not
been
available
mentioned,
Millard. I'll
and the
show
area of the land has been mentioned. Page
kindly
number
Millard
15.
takes Millard. এই তো এটা আছে তো এটা দা ফ্রি হোল্ড এই তো এগুলো ফ্রি হোল্ড this entire box is freehold Millard. The entire box is freehold.
Leasehold সব সারেন্ডার করে দিয়েছে 1758, this LR, this big.
Yes,
that was leasehold or that's freehold?
That
leasehold has not been given here.
Yes, leasehold is not there.
Leasehold is not shown here.
So Millard, he should give me either the side or the front Millard. These are all available.
Why? Will you be happy with this one? The big.
1758.
Well, there are two and two. One is 14 and one is 23. Well, kindly see. Well, if your lordship stands to page
front,
15 first,
middle, back, Millard. He has made
page 15. The deed number has been mentioned.
Millard, three categories of land. Page 18. Millard, front, middle, and back. If there is front land, I'll get less land. Front, the valuation is more. I'm ready to accept it. If I get even less Millard, I get less as per his valuation. Front valuation is more, middle is Millard in between, back is less. So if I take front, I get lesser land as per his valuation. I'm agreeing to that also.
Kindly see, my lord, page number 15 15, 16 and 17, my lord, he has, my lord, stated the deed number, description of the property, area of the land and the valuation. The valuer has been, my lord, indicated therein. And on the basis of that, his opinion, my lord, page number 17.
Mr. Chaudhary, we are not on valuation at this moment.
No, my lord, the area of the land can be given on the basis of the title deed, my lord. Whatever mentioned in the title deed, that can be given, but
This is freehold land of the company.
freehold land of the company, but
Yes.
the title deed is also there.
So you give me the freehold land. If it's the front portion, my land goes down. I get lesser land. Maybe I'll
What do you
get
mean
20
title deed?
katas.
If it's company's land, the company is the owner of the land.
Total area of the land on the basis of the title deed, my lord, he has measured, and total area of the land is 3 stage on front side, middle side, and my lord, the back side.
Yes.
Fully freehold.
Fully freehold.
So if I take
all
the front
freehold,
side,
Yes, all
why can't you agree on a particular plot of 39 katas or 19 katas as the case may be?
if it is more in the front, I get lesser area.
if-
I am agreeing to that
So,
also.
my lord, your lordships can direct the surveyor to demarcate the
Yes, Lordship will kindly.
further
In-
demarcation that the area of the land.
In
what they are
presence of
looking
both
for.
the parties.
With 39 katas.
Why do we need to direct the surveyor, Mr. Chaudhary? Why can't you and
Yes, we can.
Mr. Ghosh's client do it jointly?
If we require to hand over the property to him, I have to demarcate it. Because
First,
land-
identify there is,
Yes.
come back and tell us.
I'll do that, Willard.
We have identified, and then we'll pass the final order.
Absolutely.
So in presence of the surveyor, my lord, kindly direct the surveyor.
That-
That would be better, my lord.
Very well. Hey, Ishu,
I'm agreeing.
you're filing this report today?
No.
No, it's
Last
there.
occasion it was fine. My lord, your lordship's direction was to take the copies.
We have gone through the surveyor's report, which is on record. Stop. Valuer's report, which is on record. Stop. The valuation has been made as in 2014 and as in 2023, as per the earlier order of a coordinate bench dated
February 2024.
earlier order dated February 6, 2023. 2024, passed by a coordinate bench. Stop. Paragraph. If we go by the 2014 valuation, considering that rupees 2.25 crore was put in by
Willard,
appellant,
appellant.
by the appellant, it appears that approximately 39 katas,
39.6.
39.63 kotas of land should be handed over to the appellant. Stop. If we go by the 2023 valuation, approximately 19.15 kotas of land should go to the appellant. Paragraph.
My lord, the last order, my lord,
In all fairness, a continuous plot of land should be made over to the should go to the appellant. Stop.
In all fairness, this sort of land should be
Made over to the appellant, if available. Paragraph. Let the appellant and the an officer from the OL's office jointly, in the presence of the valuer,
same value, my lord.
identify such a plot of land and report back to us on the next date.
Kindly say freehold land because leasehold is already gone.
Stop. We understand that leasehold land of the company has already been surrendered to the lessor in terms of an order passed in a disclaimer application. Stop. Therefore, the land that will now be identified will naturally be freehold land of the company. Paragraph lists the matter.
Let the cost of the valuer surveyor
Yes,
be
of
borne
course.
by them.
Yes,
my lord.
Of course.
তার আগেরটাতেই করে দাও, আগের প্যারাতেই। This exercise will be carried out at the cost of the appellant, in the first instance.
My lord, there was an observation of the previous order, my lord. 6th February, our order suggests land of the said value today. My lord, that was the
Land of
order,
the-
my lord. That was the order
That I
mentioned
have
here.
already clarified. I have shown this order.
My lord, the order
I have already filed an application for clarification. He, as an interim order, my lord, he will give that.
What is the order? We have not
That
followed.
is the order which Lordship is reading me.
6th February.
We have no order in front of us.
6th of February, my lord, I just handed up, my lord, the last. This is the order he is reading, my lord.
That's
Two
it.
valuations, otherwise, my lord, how do I get?
My lord, in the second page, my lord.
And my lord, a clarification also leave was given. For the timing, let it to be done, you take out a clarification. That is also on board.
Second page, my lord.
Otherwise, this is the order speaks of two valuation.
What are you?
My lord, no, my lord, kindly see the third line from page 2.
Our
order
order suggests the value
land
as of
said
today.
value today.
Today. And thereafter, next, my lord, he says, my lord, in those circumstances, Mr. Ghosh's client to take out appropriate
Review clarification.
That I have sought for before. It's also pending here.
That is before us.
Yes, it's
That
there.
is there.
That's clarification
No
is
problem.
there. There's no problem. I said so on the first day. In fact, as the interim measure, the honorable bench said you take
Yes.
two valuations.
When should we keep it?
Next Friday, can I come? my lord?
You can come if you are able to do it by then.
My lord, in the meantime, shall I serve upon the
Give them copies
Grateful.
to simplify matters. If you can identify a plot so that they are not touched.
I have already said.
Yes. Talibada, list the matter. Next paragraph, list the matter once again.
2 weeks, because the surveyor, I do not know whether he would be able to.
Very well, 2 weeks.
Friday week.
Four.
তারিখটা কত? Friday week.
Friday week কত 14 নয় তো? হ্যাঁ, yes, 8.
হ্যাঁ? 8
হ্যাঁ, ওই তো।
marked
আমায় নেই।
12:45.
I'm
Marked
grateful.
12:45.
Grateful to you. দেখে নিন স্যারের যে স্টোরি তিনটে ফাঁকা থেকে তিনটে আসবে 12:45 grateful anything without touching the quarters because I'll indicate
That will only inure to your benefit.
I have already suggested no point fighting
Before rising,
My lord,
before rising.
my lord, may I be allowed to mention?
my lord.
And there was a rule issued by your lordships.
The contemner is present, my lord. Okay.
Answer the rule, file your affidavit. File your
My lord, one indulgence, my lord. The steps already been taken by the present, my lord, the Pradhan, my lord.
Say everything in the affidavit.
Lords,
If we are satisfied, we'll discharge the rule.
lords.
Issue.
My lord, personal appearance maybe. Get
Pursuant to service of the rule, comma, the alleged contemner is personally present in court. Stop. Her personal appearance is dispensed with for the time being upon her undertaking to be present in court as and if and when so directed. Paragraph. The alleged contemner will be at liberty to file her affidavit in response to the rule within 2 weeks, 3 weeks.
4 weeks, my lord, so that in the meantime we can comply with the order.
Very well, within 4 weeks from date तारीख तो दिया था. 4 weeks from date with advance copy to learned advocate for the petitioners. Stop. The petitioners will be at liberty to file their reply to such affidavit within a week thereafter, 2 weeks thereafter. Paragraph. List the matter 6 weeks hence. Date the other.
But
Under the appropriate heading.
But 2 weeks or 1 week? Reply.
2 weeks.
4 weeks, 2 weeks.
4 weeks, 2 weeks, 6 weeks.
Get full ruler.
Item number 2.
Item 2, Lordship. Not at desperation, my lord, I am submitting. Today is the date, my lord, of appearance of chairman. My lord, a standing committee has been constituted for a considerable period of time. They are, my lord, visiting North Bengal. All relevant papers are with me, my lord. My lord, I am really in difficulty, and my lord, I am beseeching, my lord. My lord, this is a relevant paper. They have taken ticket, and to my lord, at present they are, my lord, a group.
So he is not personally present.
Not personally present, my lord, because of this.
Because of what?
Because of, my lord, kindly see, Standing Committee on Urban Development and Municipal Affairs. This is the name of the different member. Lordship will find his name in 8. Dulal Chandra Das. First page, my lord.
Yes, why is the date and time? Nothing has.
Nothing is yes.
This is the committee who are the member, their name. Then I am showing, my lord. Next page.
Yes.
Next page, my lord.
Yes.
Confirmation of the railway ticket in so-and-so in Kanchanjunga Express. Standing Committee on Urban Development and Municipal Affairs, West Bengal Legislative Assembly, to the district of Alipurduar, Jalpaiguri, Kalimpong during the periods of 22nd July to 28th July 2025. This is the, my lord, the period of their visit in North Bengal.
You know that your client has been directed to appear before this court today. So you should have informed your higher officer that one date is fixed here.
No, my lord, that I have informed, and they have received, my lord, from the court summon. My court, my lord, the direction. My lord, true, my lord. My lord, this is really in difficulty, my lord. I have nothing to defend him, my lord.
Your client should have intimated his higher authority.
And my lord, they have taken ticket. Next
one date is fixed here today.
True, my lord.
He should seek
any other date, my lord. He must come. He should come, my lord. This is the direction of this honorable court, my lord. The third page, my lord. West Bengal Legislative Assembly Secretariat.
So he is not in town.
Not in town, in Alipurduar.
When will he be back?
Any date, my lord. Next date he must come, my lord.
No, when will he be back? If he say tomorrow, it will not help.
28th July.
After 28th.
20th July, my lord.
Next Friday?
Yes, my lord, next Friday.
না নেক্সট ফ্রাইডে কি কে আছে? কৌশিকের কৌশিক এটাই করে দেয়। রায়চৌধুরীদের সঙ্গে কথা হয়ে গেছে কিসের জন্য? Next Friday.
Next Friday.
Lordship, I am not on that personal appearance, but Lordship, what happened? In the meantime, what happened? Lordship, on 27th July 2025, they again issued a notice for to attend.
27th July.
23rd July. Again issued a notice. The executive
To attend when?
to attend the hearing on 30th July 2025.
Before the Board
Again,
of Councillor
but
next.
Lordship specific observation in the
So why don't you,
dated 21st.
Mr. Mukherjee, why don't you go? Why don't you go? We are keeping this matter again on the আজকে কত 25 1st of August. তাই তো? Next Friday? 1st August we are keeping this matter.
The Lordship's order is, even if it is non-appear, they are free to pass an order.
Understand now that they have, in the meantime, why don't you just go and see what happens so
Lordship,
that you can
may
report
I
to
say
us?
one thing, Lordship?
Yes.
This is absolutely unfortunate that this old aged person's learned senior advocate went to the hearing. Now 45 minutes he is allowed to stand, not allowed to sit. Absolutely misbehavior, Lordship. Nana wants to go in the office of the concerned chairman.
Do whatever you
I
like.
don't want to say these things, but Lordship, I happen.
Elisho. Mr. Chakraborty, learned advocate appearing for the alleged contemnor, says that the rule was served on the alleged contemnor on July 22, 2025. Stop. On that day itself, he, along with several other members of the Standing Committee on Urban Development and Municipal Affairs, visited Alipurduar, and the alleged contemnor is still in North Bengal. Stop. He is scheduled to return on July 28.
After 20. Up to 28, that meeting, that.
Scheduled to retire immediately after July 28, 2025. Stop. Paragraph we see from the lay note dated July 24, 2025, prepared by the Assistant Registrar Roman 4, that indeed the alleged contemnor received notice of the contempt rule on July 22, 2025. Paragraph lists this matter once again on August 1, 2025. Stop. On that day, the alleged contemnor shall be personally present in court.
Hearing, my lord, of Board of Councillor on 30th, my lord.
We are not saying anything. Let them decide if they want to go.
Deeply obliged, my lord. Deeply obliged. Great.
That for the
You are the review applicant.
No, I am the review applicant, my lord. On section 5, my learned friend has taken out an objection. I am filing my reply, my lord, along with a supplementary.
Supplementary?
Yes, supplementary, my lord, to this affidavit in reply, my lord.
Possibly, my lord, for the application for the review application.
Yes.
Supplementary not of this one.
No, yes. No. That's what I wanted to submit, madam.
How much delay? 326 days.
Yes, madam. But my learned friend's contention was that delay has not been properly
So
explained.
supplementary, how can you just file? Did we grant you leave?
No, supplementary to the review, my lord. To the review, my lord. I have not filed as yet. But only thing, my lord, the reply to the affidavit in opposition to the, my lord.
Yes, we'll take the reply.
Yes, yes.
Yes, now
And
how
it's
do
there, my lord, I just submitted that it is also there.
Yes.
My lord, I have, my lord, tried to explain, my lord, the delay by showing the document. My lord, the fundamental issue in the appeal was that the notice was not served upon them. At that material point of time, nothing could be produced. But subsequently, on rigorous search, my lord, the documents have been made available, which would demonstrate, my lord, that the notice.
What is your explanation for the delay?
The delay I have explained, my lord. Your lords will kindly see.
Can two or can one?
Paragraph 6 onward, I have tried to demonstrate, my lord. And from my reply, my further details, my lord will get. You took so much time for consultation and everything. Yes, my lord. This time, my lord, practically taken. But I have even, my lord.
That I pointed out.
My lord,
That was
এক
first
minute,
of
all
all,
of
the
এক minute.
commission.
এক minute. My lord, in my reply, my lord will find I have disclosed the documents also. From 10 page 10 onwards, my lord will find, my lord, how the file, my lord, circulated. In my reply, my lord, I have given. I've given the documents.
Yes, why should we forget about delay for the time being? It's taking the document that you now propose to rely upon. It was always in your custody, in your possession.
My lord, it's true. But it was not readily made available at that point.
No.
in time.
That is a vague, Mr. Banerjee. We will say you chose not to produce it.
My lord,
You will say no, that is not correct. We will not accept your
my lord,
contention.
sometimes, my lord, truth is stranger than fiction.
No.
But sometimes it happens, my lord. Sometimes it happens. It's not that it is vague or, my lord.
It was vented
The
depending on other issue also.
grounds, one of the ground under Order 47 Rule 1 has to be made out.
Yes. But I have submitted that it was not there and that it is, my lord.
What do you mean not there? It has suddenly fallen from the sky.
No. My lord, it was a vigorous search was made. Ultimately, the
It is the registered daily for daily use.
আপনি বলবেন অলকদা আমি বলিনি একটু আপনার তো টার্ন আছেই আমার তো
দাদা,
টার্ন নেই
section
এমন
by-
Something which you could not produce in spite of exercising due diligence, that we may consider.
Yes, my lord, it was
Not
tried,
any
it
and everything.
could not be found, my lord, because notice book, my lord, is not single.
You better go higher up. We are not believing your story in your condonation application, but we will allow that application, taking a liberal view, and dismiss your review application.
Your lordship will kindly consider, my lord, for
With costs. Now, the more you address us, the cost will go up. That is all.
my lord, but I entirely, my lord, at your lordship's mercy.
No.
Only thing, my lord, your lordship would, my lord, even if it is,
Hey, order CPC to the.
my lord, your lordship fine. Wait. এখানে আছে একদম বলেই দিয়েছে আর কি ডিউ ডিলিজেন্স না হলে হবেই না
Look at the language, Mr. Banerjee. Has to be given some meaning, this language.
My lord, I am not on that. Your lordship will kindly see, sometimes it has been held or for sufficient reasons. Your lordship will kindly see, sometimes this happens that it could not be the notice, peon book, my lord, to which it was served.
Go higher up.
It was 41 rule 20. But I'm having the book, my lord. I'm having the book. But sometimes it happens, my lord. That's why, my lord, I cannot improve more than that. It was the bare fact, my lord, that it was not made available or could not be produced before, my lord. And fact remains, my lord, after vigorous search, it could be found out. But now it's entirely up to, my lord, because the fundamental of the judgment, your lordship kindly allow me one or two. The fundamental of the judgment was that the notice was not served. Now, if that it appears that the notice was served upon them, then, my lord, the entire thing requires, my lord, a reconsideration by my lords. If your lordship will kindly consider that aspect of the matter.
And what have we said in the judgment? What have we done? We have asked you to hear him afresh.
Yes. Only thing, hear him afresh. Or only one more thing, my lord, I have said, that the no objection certificate, no objection certificate, my lord, subject to today, my lord, I am not having those papers with me. But it always, under a waiver scheme, it is written that if any other
If you
dues
do
are
not
there-
have supporting papers, do not make submission.
No. Always in a waiver notice. Because today, I thought only section 5 will be taken up. That's why that bunch of papers I could not.
So if you are not ready, come back ready.
And if your lordship kindly allows me to file this supplementary affidavit to the review application.
What is there in the supplementary?
But only the document showing that the notice was served. That documents I have disclosed, my lord.
That even you did not annex to the stay petition. That is the whole purpose of review.
Yes, it was.
Your whole entire ground of review is this notice.
Here, my lord, could not annex it, my lord. Subsequently, I found it. Then, my lord, supplementary.
How does the corporation?
Heavy cost with heavy cost.
My lord, this is, my lord, I am at your mercy, my lord's mercy.
Everybody is
This is the
at our-
position, my lord. I'm feeling embarrassed rather that this is the position, but the fact.
File it, give a copy to him.
Yes. Yes, ma'am.
Likho.
Copy dijo.
Affidavit in opposition
Yes, ma'am. Copy has been served.
and affidavit in reply filed in connection with the application for condonation of delay be kept with the records. Paragraph. The supplementary affidavit filed on behalf of Kolkata Municipal Corporation is also taken on record. Stop. A copy of that affidavit has been made available to learned advocate for the respondent in this review application. Paragraph. Mr. Ghosh, we will consider.
I'm submitting to your lordship, I follow my lord, but I have something to say because that entire process has been started. But section 5 application to be viewed, my lord, depending on the situation. And here in this case, the your lordship order was a specific direction with a time frame for compliance with the order. Then after that period is over, even they did not bother, my lord, to take a decision, and decision has been changes from one occasion to another occasion. Repeatedly.
We read the petition.
Submitting to your lordship, my lord, while considering the issue, both be heard together. Because I want, my lord, some observation also on the application for the conditional delay, and together with your lordship consider that. And I will file that opposition to his stay application because, my lord, the document which is lying now, I'll point out, well, what is the fallacy in this document.
Very well,
And
very well.
also the court has been prevented because of such a situation from deciding on other important issues. On other important issues.
The respondent would be at liberty to file his affidavit in opposition to the stay petition and the supplementary affidavit within a fortnight from date. Stop. Reply thereto, comma, if any be filed within a fortnight thereafter. Paragraph, let the review application, comma, the stay petition, stay application, and the application for condonation of delay be listed together. 2 weeks bollam na, ki bollam? 4 weeks since. Date ta diye do.
Well, I have already filed the appeal for contempt. That should also come along with this.
Where's the number?
It is possible in the list. Number 4. I don't know 4 today.
The item number 4 ta ওইটা দিয়ে দাও, let's see না সি প্যান না কি হবে? সি প্যান 56 556 of 2025 be listed along with these matters on the adjourned date.
হাসিনার শুলে চড়ানো কি হবে? এটা কপি দেন? ও আগে ফাঁসাবে তারপরে ঠিক আছে। আমি
Bring necessary authorities. It won't be easy for you.
Yes, I shall try my level best. I shall try my level best.
Yeah. You are for the contempt, no?
No, no, for the petition. But kindly consider page 22 of the application.
First time?
This is first time.
Oh, page 22. Yes, contempt was withdrawn, liberty to file afresh.
We have filed that.
If filed within a fortnight from date.
That was filed within fortnight.
Within a fortnight. 26 July.
Formed on 8th August and filed on 8th August.
Why is it listed after 2 years?
Bench was not.
Bench was one of these.
No, this bench is regularly available, Mr. Sanyal. Regularly. Anyway. So serve then, let us see. So what was the nature of the order?
That's your lordships will find that order dated 14th May 2014.
Page of the contempt.
Just leave it.
Which page?
Page 62.
Page 62.
No, see, bargaining also should. Bargaining also.
It is available here. Proceeding of administration.
What is the act of contempt?
We had deposited rupees 5 lakhs as per your lordship's order.
You are Komul.
Yes. We had deposited. Page your lordships will find.
So Topun has not yet conveyed the property to you. Serve. Hey. This contempt application has been taken out for alleged willful violation of an order dated May 14, 2014. Jagyashu. Mr. Sanyal, what about limitation?
Limitation to wait for it.
Anyway, let them come and take the objection. Let us see. Alleged violation of order May 14, May 14, 2014, whereby FAT 512 of 2013 was disposed of by a coordinate bench of which one of us, Rakita was a member. Paragraph.
It was within limitation.
In the earlier order, your losses had taken note of that, but in spite of that, your losses was pleased to give us liberty to
The
file.
operative portion of the said order reads as follows, page 63 theke. Set out bracketed portion. Paragraph, Mr. Sanyal, learned senior counsel representing the petitioner, says that the entire money No, 5 lakhs. 5 lakhs you deposited.
Yes.
With Mr. Roy,
Then
Chandrasekhar Roy.
Dr. Roy again.
Entire money.
Roy.
Entire money, na? That the sum of rupees 5 lakh was deposited by the petitioner with Mr. Chandrodoy Roy,
Who subsequently,
comma, the petitioner's learned advocate,
because there was no execution, he returned the money.
in terms of the said order.
But
Stop.
subsequently, he returned the money since they didn't execute the. Let us come back. Otherwise,
Stop. However, the alleged contemptor did not execute the conveyance in respect of the concerned property in favor of the petitioner, comma, in violation of the said order. Paragraph, let a copy of the contempt petition be served on the alleged contemptor and affidavit of service be filed in court on the next day. How long will it take to serve? We are assembling again next Friday.
that we can serve next week. Yes, sir, keep it on next Friday.
Further, list it on. Money.
Sir.
No problem.
No problem.
May 2014 to end October 2013. March, 7 March.
Lordship, in this matter, Lordship, Mr. Shondipan Banerjee is appearing on behalf of Howrah Municipal Corporation. He is actually engaged in court number 15, Lordship. So, allow us a short passover, Lordship. Grateful, Lordship.
AC Augustine.
Sorry,
7.
Chalo.
Number 8.
Yes.
The report was to be filed by the KMC.
Mr. Tiwari, we'll run through the list once. দেখে যাও একবার পুরোটা কল করো।
It is our application.
Very well. Second call, huh?
I am for alleged contempt in item number 10, my lord.
Next.
Number 11.
I can cover the container number 4.
Number 12. Item number 13.
My lord, I am for the petitioner in item number 13.
14. I am for the petitioner. 15.
My lord, in item number 15, I am for the petitioner. It is appearing for the first time.
14 also first time, my lord. 14 is also.
তাহলে 14টা আগে দাও 14টাকে দাও।
Yes.
আমি কোনো ডিসিপ্লিন অ্যাকশন ভাবছি তুমি আমাকে বারণ করবে তুমি চলে যাবে এখনো সমস্যা হবে চিফ জাস্টিস ওরা ভালো
Yes, where's the order?
My page 16, it's starting, my lord.
Huh?
Page 16, my lord.
16.
Yes, my lord. 1-6.
Last time.
First.
What is the act of contempt?
My lord, the construction was, my lord, made, my lord, was of G+2. My lord, the sanction plan was of G+1. So, my lord, may kindly takes a page 20, the second paragraph, my lord. The second floor, my lord, has, my lord, directed to be, my lord, demolished, my lord, within 8 weeks from the date of communication of the order. And with regard to ground +1, my lord, they have submitted that they have made an application before the corporation requesting if, my lord, they can be allowed to make, my lord, new pillars within the authorized portion so that, my lord, that can be saved and, my lord, thereafter the deviated portion can be demolished. So, my lord has directed that application to be considered within 8 weeks to, my lord, from the date of communication of the order. And nothing has happened till now, my lord.
I see. Hey. No, sorry. This contempt application has been taken out for alleged willful violation of a judgment and order dated September 13, 2023, whereby MAT 1370 of 2023 was disposed of by us along with the connected applications. Stop. Paragraph. One of the directions in the said order was on the Howrah Municipal Corporation to dispose of the representation made by
My lord, the appellant.
The appellant.
Yes.
Who appellant? Appellant নামটা দিয়ে দাও Trilochon Dash, appellant, Trilochon Dash, as regards the alleged unauthorized construction made by him.
They have prayed for permission to make construction of new pillars within the authorized portion.
Made by the appellant. করে দাও. Stop. You were the respondent. You were
I
writ
was
petitioner.
Yes, I was the private. Yes, my lord.
Writ petitioner.
I was the private respondent, my lord. They have challenged, my lord, the order of
Were
demolition.
you the writ petitioner?
No, I was the
or
writ
no?
respondent.
Paragraph learned advocate for the petitioner says that the representation of Trilochon Dash is still pending in spite of passage of a long period of time. Paragraph, let a copy of the contempt petition be served, a copy na let copies bolo, of the contempt petition be served on the alleged contemnors, and affidavit of service be filed in court on the next date.
Copy may be served.
কি বললাম, an affidavit of service. Paragraph. At this stage, Mr. Shondipon Banerjee, learned advocate, appears and says that he is authorized to accept service. Stop. Let a copy of the contempt petition be made available to him in course of the day. Paragraph, the alleged contemners will be at liberty to file affidavit in opposition.
Get it considered. That I can see. If you notice, give
My
me
lord.
6 weeks time. I will get it considered and come with the report.
No.
That I can submit. I will get it considered and come with the report.
Why this delay?
Given a time.
Why we should not immediately issue a rule? 8 weeks or 10 weeks we had granted in 23.
Idiot.
I have to take instruction.
Yes, you have to give an explanation. You cannot comply with the order at your own sweet will. When we say 10 weeks, you take 10 months. Not acceptable.
My lord, the other portion of the order was to, my lord, immediately demolish the second floor. That has not been also done. The representation was about ground plus first. The second was directed to be immediately demolished.
You will learn. Hey. Affidavit in opposition within a fortnight from date. Stop. Reply thereto, if any be filed within 5 days thereafter. List the matters 3 weeks hence. List the matter after 3 weeks when this bench is again available.
I pray for leave to add the present incumbents, my lord.
Goratte diye dao. Leave is granted to the advocate on record for the petitioner to add the present incumbent in the post of Commissioner, Howrah Municipal Corporation as respondent number 3.
As well as the assistant engineer borrow 7. As well as the assistant engineer borrow 7. There are 2 contemners, my lord. Both have changed.
এভাবে লেখো leave is granted to the learned advocate on record for the petitioner to add the present incumbents in the posts of Commissioner, Howrah Municipal Corporation and Assistant Engineer,
Borough 7, Howrah Municipal Corporation.
Borough 7, Howrah Municipal Corporation as respondent numbers 3 and 4 in the contempt application. Stop. Let necessary amendment be carried out in the cause title of the contempt petition.
Great.
Yes, he said so.
My lord has it.
Next, দেখো টেবিলটা ছোট।
My lord, I am for the petitioner. The contempt application appearing for the first time. My lord, on 17th November 2023, your lordships directed the Pradhan of the Kamrabad Gram Panchayat to consider the representation of the petitioner. But till date, the same has not been done, my lord.
original সাইটটা তোমার প্রশ্ন রাখবো। এসো। This contempt application has been taken out alleging willful violation of an order dated November 17, 2023, whereby MAT 2013 of 2023 was disposed of by us along with the connected application. Stop. The operative portion of the said order reads as follows: colon দিয়ে page 31, running page 31 থেকে set out. Paragraph. Learned advocate for the petitioner says that in spite of due communication of the order, the representation, the petitioner's representation has still not been disposed of by the alleged contemnor in spite of passage of over 2 years. Over 2 years. Paragraph. Let a copy of the contempt petition be served on the alleged contemnor and affidavit of service be filed in court on the next date. Paragraph. This is the matter.
2 weeks, my lord.
After 2 weeks, whenever this bench is again available.
My lord, I am for the petitioner. Your lordship's order.
First time?
First time, my lord. 14th March 2024, my lord. Page 18. Operative portion as page 24, my lord.
সুপ্রতিম তো available. এইটা কি করে হবে এখানে? 14th March 24.
14th March 2024.
The bench of Justice Supratim Bhattacharya and me. Then how can it be heard here? এটা একটু বেঞ্চ করে দেবে। এই কিছু বলতে হবে? This contempt application has been filed for alleged willful violation of an order dated March 14, 2024, passed by a coordinate bench. ব্র্যাকেটে আমার দুজনের নাম দেবে, আমার আর সুপ্রতিম ভট্টাচার্য। Very close. Stop. This bench cannot take up this matter. Stop. The matter stands released from our list. Stop. Let the matter be placed before the appropriate bench. About
70, my lord, I am not the petitioner. But the contempt I use an affidavit in opposition, but this is our reply. You also can't deliver. There's no reply.
Other side in.
The other side is not here.
But 18 also same. Same order.
Affidavit in reply filed on behalf of the petitioners be kept with the records. Paragraph. The alleged contemnors are not represented today. Paragraph lists the matter next Friday. Next Friday, date thou. Stop. Learned advocate on record. It paragraph. For the petitioners shall inform learned advocate for the alleged contemnors that this matter will be taken up on such and such date. Same order 17, 18.
18 reply.
Next 19.
My petition in alternative of acquisition
First time.
no. Can you see the last order liberty was given to the me to accept this amount without prejudice to my rights. I went there, they didn't pay. Following their proposal, we have given the calculation. I'm a poor man. Let them pay this amount and then decide.
Yes.
Mr. Rovindranath appearing is coming, my lord. He is engaged in court number 14. He is coming, my lord.
We'll wait.
Yes. Not pass over, my lord.
Second time what time? For the day, without the prejudice, this amount can then come on the next day, Next Friday.
The amount of
Next Friday.
Next Friday.
My lords, I appear for the petitioner. My lord, there was a direction for exchange of affidavit, but no opposition has been filed till date.
Order to the.
Because on the last occasion, there was a direction upon us, my lord, to file the opposition. We have already prepared the opposition, my lord. Some time is required, my lord, due to the difficulty of the alleged contempt.
Difficulty of?
There's some difficulty with health issues, your lordship. They're suffering from some problem, your lordship. That's why they cannot come for the affirmation, my lord. We have already prepared, your lordship. Kindly gives us some time, your lordship. We'll file in the meantime.
We have given you 2.5 months.
My lord. My lord, all the documents, my
You'll
lord,
get till next. You'll have to file it by next Friday. On behalf of the alleged contemnor, extension of time to file affidavit in opposition is prayed for. Paragraph, we see that direction for exchange of affidavits was given on May 2, 2025, i.e. more than 2.5 years ago, 2 months, years now, 2.5 months ago. Stop. We do not appreciate this lackadaisical approach on the part of the alleged contemnor. Paragraph, however, for the ends of justice, time to file affidavit in opposition is extended by a week from date. Stop. Reply thereto, if any, be filed within a week thereafter.
Lord, kindly makes it 2 weeks.
2 weeks thereafter. Paragraph lists this matter after 3 weeks, whenever this bench is again available.
Lord, kindly gives them as a last chance, my lord, for them to file.
The 21, my lord, in this matter, the petitioners are considered with the proposal of direct purchase policy of the state as well as the compensation. Initially, the order was to pay compensation under 2013 Act.
First time.
No matter, not first time, but if you logically take up the matter, the first three items in the next week, matter may be disposed of because they have considered to the direct purchase policy.
Very well. So, not today only. Not today.
Next
Not
Friday,
today means
within first three items, my lord, if you
এই
logically.
তুলে it will be maybe disposed of.
Yes, my lord.
এই তুলে দাও উপরে কন্টেম্পটের উপরে তুলে দাও 21
I'm good.
My lord, I am for the petitioner. Last occasion, lordship directed to affidavit in opposition and reply. This is the reply. My lord.
Complied, my lord, order.
Complied?
Not complied.
May I say, I represent the district magistrate. My learned represents the municipality. While disposing of the appeal, my lords had directed that a group of employees who were, my lord, dispensing certain menial works had to be, whether there is any scope of regularizing their work under certain provision or not, that has to be considered. My lord, we had indicated to the municipality that
order dated.
My lord, kindly see this order 30, page 33.
Huh?
33, lordship. Order dated the 15 December 2023. Page 33, 34, the ordering portion, the relevant portion. We only clarify 33 last line. We only clarify that the process for filling up these vacant sanction posts in accordance with law, direction passed by the Honorable Apex Court in the case of Umadevi Supra be initiated and completed by the municipality after obtaining immediate permission from the Director of Local Bodies within 6 months from the date of communication of this order, a mandatory order. After obtaining their permission from the municipality, from the DLB, there's nothing.
As per instruction of
Yes, you have not filed your affidavit.
I have just received the copies of the application last week. It was my mistake, I admit. It was served upon the department, but somehow there was a.
Why do you say your mistake, sir? Why?
I take it on me, but
No, you cannot. You should not. Please learn this.
I have already drafted and sent the affidavits.
How long will take? 1 week.
1 week, maximum 1 week.
Hey, issue. Affidavit in opposition filed on behalf of the alleged container number 3. Be kept with the records. Paragraph.
Reply.
You are for 1 and 2.
I am for 1. Only 1.
Only?
Yes, 1 and 2.
Learned advocate for alleged container numbers 1 and 2 seek extension of time to file affidavit in opposition. Stop.
Yeah,
Such time is extended.
Yes. Director of
sanction the post. DLB
is not made a contempt now.
That is their problem.
That is their problem.
Extended till August 1. Huh? August 1. Paragraph. Have you filed your reply to their opposition?
Already filed.
Paragraph. The petitioner will be at liberty to file Meena Robidas, lady or male?
Two ladies, my lord. Meena is lady. My lord, 22 is lady, 23 is lady, and 24 is a male.
24 not. 22, 23.
22, 23.
24.
File her affidavit in reply to reply within a week or 2 weeks. Within a week thereafter. Paragraph lists the matter after 2 weeks whenever this bench is again available. Same order in 22,
22, 23.
23 and 24.
24 এটা ইয়ে হবে তোর him হবে his affidavit. Oh, 23 আর 24 এও সেম অ্যাফিডেভিট গুলো নিয়ে নাও।
23,
23 এটা 23 আর এটা হচ্ছে 20 এটা 24
23, 23 তে রাখবেন।
এই মিস্টার দত্ত, হোয়াট ইজ
22 23
24.
what is your explanation?
Well, we had indicated to them that you take your own call, but they have said that unless you give us the rules, well, we are saying that there is no rules as of date.
22, 23.
There is government has not framed any
23,
rules.
24.
The municipality can take their.
For instance, direction of the DLB municipality submitted relevant documents. Then
The vacant posts are available, but they are easy to initiate this process. This is the problem, my lord.
রাখো, কি করছো? সেকেন্ড কল?
This is my application. Lordship sees the last order, my lord, on 16th of May 2025.
Please coming Lordship, Mr. Shondipan Banerjee is appealing for the Howrah Municipal Corporation.
Okay, chapter. But till date, this has not even been complied.
Full compliance report was to be filed today. Anyway, sir, we'll have to take up a fixed matter at 3 o'clock. Come back next Friday. Next
But
Friday.
till date, my lord, this has not yet been complied with also.
Madam, please tell Mr. Banerjee, are you briefed in the matter? Mushkil. Read last day's order. He was to file a compliance report today. So, let. Chalo, original side na dekho.
My lord,
hold on.
permitted to mention regarding item number 10, my lord. Short thing, my lord.
What?
My lord, actually, I am for the alleged contemner, my lord. The contemner is DM Murshidabad, my lord. He could not come. He has sent the affidavit affirming before the notary public, my lord. The department asked for the leave of the my lord to file, my lord. My lord, kindly, I am praying a leave to file this.
Why will he not come?
My lord,
Why?
today is the last day we have prayed for. My lord.
So let him go to
please-
jail then.
My lord, the affidavit is ready, my lord.
Why hasn't he come before and affirmed it? Knowing that it was to be filed today?
My lord, it's affirmed before the notary public and.
Is that the rule?
No, my lord. My lord, okay, my lord. He will come and affirm.
We
within
are
2
not
days.
saying anything. Do whatever you like. Next day, if we don't get the affidavit, we'll issue a rule.
No, my lord.
Chalo,
Great.
original side to that.
Do you have picked, sir, item number 1 and 2?
Mr. Odhikari, sorry, okay, we will release you today. Come back next Friday. এই পরের দিন মিস্টার অধিকারীর মামলাটা একদম টপে দাও তো। পরের দিন ফ্রাইডে আইটেম নাম্বার 9টাকে তুলে দাও একদম। হ্যাঁ, 21 আর 9টা উপরে থাকবে। So you will take some more time.
Only 10 minutes, then.
No, my lord, I would not want to, my lord, this being a Friday, I wouldn't want to make a lordship stay back beyond 3:30. Mr.
Will you
Mitro,
complete next Friday if we give you half an hour?
if your lordship gives me,
We can't give you more than half an hour. You have to complete. We can't. This has to stop
has to
at
stop
some
somewhere.
point
It's
of
all
time.
good thing for Mr. Mitro in a different way, must come to an end. In the meantime, Mr. Mitro went down, but because I was not there, my lord, to assist him, the matter got adjourned before he arrived.
Mr. Roy Chaudhary, Mr. Mitro is leading you. Achha. One Mr. Shushen Mitro is wearing a new pair of glasses. I'm noticing, which is looking good. देखो, Mr. Banerjee, our senior counsel representing this you are arguing on the appeal.
On the appeal.
The appellants in MAT
617 of 2023.
resumes his argument but does not conclude. So he promises to conclude on the next date. Really, Kona. Next. List this matter once again on Shamne Shukrubari did the. Please finish up next day because we'll have to hear them also.
May I wish your lordships not a happy weekend, my lord, a very happy and merry weekend.
Thank you. Same to you.
And we wish everyone.
I see the bed. I only the bed.